Kevin Lychwick, case number 24CF1881. Appearances, please.
Good morning, Your Honor. The state appears by Chelsea Thompson and Dan Tombasco, along with Detective Ben Stern at counsel table.
Good morning. Mr. Lychwick appears in person in custody. Good morning, Mr. Lychwick.
Good morning.
Also present in the courtroom is standby counsel Attorney Pablo Galaviz. Attorney Thompson, does the state continue to be in victim rights legislation compliance?
Yes.
Thank you. We called the case early today before the jury comes back at 9 o'clock to discuss jury instructions. I wanted to just take this opportunity. It seemed to be the best time to take the break to do the jury instruction conference so that we can quickly move through the evidence and instructions and closings once the jury comes back. My clerk has provided an updated version of the jury instructions to the parties today. What I typically do is I go through the instructions up on the screen here. I'll go through each instruction. My clerk will put them up on the screen, and I will invite comments, but silence I interpret as acquiescence to the instructions as presented. So if they're fine, you don't need to say anything unless you have a comment or request something else. So, Madam Clerk, let's put the instructions up. We start with 100. That's a standard instruction. Any issue with 100?
None from the state.
Okay, again, I'll take silence as acquiescence.
Okay, fair enough.
Let's go on to 110 then. I moved 110 up before the substantive instructions based on the first draft that went out. Madam Clerk, could we just make instruction 110 single space to make it consistent? Okay, she'll fix the formatting a little bit, but substantively 110 just mirrors the charging language in the information. I am going to change victim A to Carlos Maldonado. I understand the victim designation in the charging documents, but at this point, Mr. Maldonado has been referred to by name. Any other changes to 110? All right. Instruction 70. I inserted here. I also have the additional line that's not standard in 70. It's about standby counsel being appointed. This is the same instruction that I gave at the beginning of the trial. Any changes to 70 as presented? Okay. What I propose here is to add something to 70 to address the defendant's clothing. I know when the defendant first appeared in Jail Orange, I gave the instruction to the jury that they are not to consider his change in appearance and his change in clothing. I'm proposing something that's similar to instruction 314, which is to be given when the defendant is wearing a visible restraining device in the presence of jurors. It would simply be that a sentence is added to 70 saying the defendant has appeared in court wearing orange clothing. This must not be considered by you in any way and must not influence your verdict in any manner. What does the state think of that proposal?
No objection, Your Honor.
Mr. Lychwick, what do you think of that proposal?
No objection.
Okay, then we'll add that the defendant has appeared in court wearing orange clothing, period. I think I'll add, you must not infer anything from this. And this must not influence your verdict in any manner.
Period.
This must not influence your verdict in any manner. And also change the spelling. I think you got infer now. I-N-F-E-R. All right, as presented, is that still okay with the state?
Yes.
Mr. Lychwick?
Yes.
Very well. Then instruction 110 is the standard first-degree intentional homicide instruction. It does use the victim's name. Madam Clerk, can you make this left justified, please? So just highlight the instruction and then, no, just the individual text. Nope. Below that, line below that, you see the center is highlighted? To the left of the center. Nope, other one. There we go. And then put a paragraph.
You want me to do it every?
Yep.
Sure.
And then could you, first paragraph or first line indent on those paragraphs too?
Oh, yeah. I think I copied and pasted from the PDF. Didn't work very well.
Go back to that last paragraph, please. Okay, and then deciding about intent, we'll fix that. Intent and motive, we'll fix. Any other changes to 110 or requests for any additional instructions from the state?
No, Your Honor.
Mr. Lychwick?
None.
Very well. Then 194 is standard. If we can just put the first line indents, thank you. And then for elements, please separate out 1 and 2. So put 2 on the second line and give it one more space in between there.
Sure.
Thank you. Other than that, that instruction is standard. Any changes? Okay. 140 is a standard instruction. Madam Clerk, if you could just put extra spaces between the text and the heading. There you go, just like that. .145 is standard. 103 is standard. Can we break those paragraphs up, please? 162 we don't need. I don't believe there have been any stipulated facts.
I agree, Your Honor.
Okay. We'll take 162 out. 165 can be removed. There are no judicially noticed facts. 170 will remain in. Circumstantial evidence, we'll just take out the all caps language and also break those paragraphs up. Is the state requesting 172?
Yes, Your Honor.
Flight, escape, and concealment. Mr. Lychwick, any objection to 172?
Would you please go over that again?
Sure. 172, a flight, escape, and concealment is a supplemental instruction to the circumstantial evidence instruction of 170. What it says, or how it would read, is that evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. The state is requesting that. I'll hear an objection if you have one.
So the state wants this in?
Yes.
I object.
Okay. Noting your objection, I am going to give 172 primarily because one of the crimes is hiding a corpse, which itself is conduct after the alleged offense was committed. There's also other evidence that I believe would be relevant to having instruction 172 given. So we'll use the after the alleged crime was committed language. And unless the state wants the second bracketed language as well, Attorney Tombasco?
No.
Okay.
That's fine, Your Honor.
175, is there a request from the state for 175 motive?
Yes, Your Honor. I apologize for interrupting. Yes.
That's fine. Mr. Lychwick, do you want 175 or do you have an objection to 175? That is the instruction dealing with motive and that it is not. I'm sorry?
No objection.
Okay, then we'll include 175. I think it's appropriate given the charge of first-degree intentional homicide and the mention of motive not being required and different from intent in the instruction itself. So we'll take out that those brackets. We'll leave that language in. And then we'll leave that second paragraph as is. All right. 180 deals with statements of the defendant. The state has introduced video statements, so the court will give 180, and we'll use the plural. We do not need the optional statements about the lack of audio or visual recording because the only statements the state introduced were the recorded statements, I believe. Is that correct, Attorney Tom Bosco?
Yes, that is correct, Your Honor.
Okay. So we'll take that out and then continue with the final paragraph of that instruction. Instruction 270, I don't believe we need. We can take that out. 157 will stay. I will modify 157 to say, right, remarks of the parties or parties. And then I'll say remarks of the parties are not evidence. Any objection to that change, Attorney Tom Bosco?
No, agreed, Your Honor. Thank you.
Mr. Lychwick?
None, thank you.
154 is summary. The state did introduce that timeline, which would be a summary. So based upon that alone, the court will allow 154 to be read. 155 is standard for exhibits. 148, we did have objections and evidence received. We'll change objections of counsel to objections of parties. Yes, thank you. And then in the second paragraph, too, by allowing testimony or other evidence to be received over the objection of parties, of the parties. 147 is standard for improper questions. The court did not allow some questions to be answered, so that will stay in. 150, I don't know that we had stricken testimony, but we had some stricken comments.
Mm-hmm.
Is there a request from the state for 150 to stay in?
Yes, I would. I don't know if we want to modify it to stricken statements rather than testimony, but
I'd
somehow.
leave it as is, but Mr. Lychwick, do you have any input on 150?
I have no objections.
Okay, I'll leave 150 as is. 190, weight of evidence is standard. 195, juror knowledge is standard. 300, credibility of witnesses is standard. Could we just break those paragraphs up a little bit for ease of readability? Mr. Lychwick, at this point, and I am not asking you for your final answer yet. I have not taken your waiver colloquy on your right to testify, but are you still anticipating that you will not testify?
Yes, I am, Your Honor.
Okay. Then for this credibility instruction, we will for now take out the paragraph to be given only when the defendant testifies. If, Mr. Lychwick, you change your mind about that, we can go back and modify this instruction. Then 315, Mr. Lychwick, if you do not testify, are you wanting 315 in there? It is an instruction to the jury that informs them of your constitutional right not to testify and that they must not consider your decision not to testify against you.
I want that in there, please.
Okay, then the court will give 315. We'll just break those two sentences up. 141, identification of the defendant.
Judge,
Attorney
I think,
Tom Bosco?
yes, thank you, Judge. I think I don't think, I think it should be removed now. The only area where it might have been an issue was on the trail cameras, but I think as Mr. Lychwick has acknowledged yesterday, he said it was him, so I don't think that there's an issue regarding identification. I asked that it be removed.
Well, his statements that it was him are not evidence, and those would be regarding the statements of the parties that the court has instructed the jury not to consider. But still, I'm inclined to agree with the state. I think this instruction is more appropriate when there is an eyewitness to the crime who identifies the defendant as the one who committed the crime. Here, the only real question about identification was identifying the defendant on surveillance cameras and the trail cameras, which doesn't really get to the spirit of 141, I don't think. Mr. Lychwick, do you want instruction 141 to be given?
I want it removed.
Okay, then we'll remove 141. I don't think it's necessary in this case. Instruction 200, we have had testimony that could be considered expert testimony, so we'll leave 200 in. We'll just remove the word expert from that. And we can take out the optional paragraph at the end about conflicting expert testimony. We didn't have any of that. 201, opinion of a lay witness. Again, we'll take out non-expert in the title of that, but certain witnesses have been given the opportunity to offer an opinion based upon their experience, so my inclination is to leave 201 in. I don't know that we need to identify the specific witnesses who are allowed to give opinions. We could have it read, ordinarily a witness may testify only about facts. However, in this case, witnesses were allowed to give opinions based on their experience in determining the weight you give to this opinion. You should consider the witness's opportunity to observe, et cetera, et cetera. That way we're not highlighting any particular witness, but just acknowledging that certain witnesses have been able to give opinions. Attorney Tombasco, any thoughts on 201 as modified?
No, Your Honor, I agree with the court's thought process.
Mr. Lychwick, any opinion on 201 as modified?
Not at this time, Your Honor.
Okay, then we'll give it as written now. We did have hypotheticals, so the court will give 205, and we'll just remove the word expert. .320, I don't know that we had prior inconsistent statements, so we can remove 320. Attorney Tombasco?
I would intend to agree. The only thing I'm a little bit hesitant is if he testifies, it might become an issue, but at this point, I would agree.
Sure. If Mr. Lychwick testifies and that becomes an issue, we can add it. Otherwise, 320 will come out. 325 can be removed. We do not have any witness with prior conviction. 327 similarly can be removed. 340, credibility of child witness, can be removed. 160 is standard. We'll change that to parties. Thank you. And then 460 is standard. We can change counsel to parties in that instruction as well. Let me just put the parties in both of those changes just to make it read a little better. And then we'll use the plural of offenses. And then 480. So we'll have two verdicts on each count. The first verdict will be guilty of first-degree intentional homicide as charged in count 1. Second will be not guilty of first-degree intentional homicide as charged in count 1. Then put a space in between. There you go. Thank you. Can you also first line indent those?
You want me to,
Yes, please. Thank you. Then similarly, we have guilty of hiding a corpse and not guilty of hiding a corpse as charged in count 2. Otherwise, that instruction is pretty standard, and then our verdict forms will mirror that language. Then 515 is standard instruction.
Excuse me, Your Honor.
Yes, sir.
Could I have 480 reworded for reversing this to one reading, we the jury find the defendant, myself, not guilty, before guilty is placed in the text?
Any objection from the state?
That's fine, Your Honor.
Okay, the court will make that change. And then, Mr. Lychwick, what I will do is when the physical verdict forms are presented to the jury, I'll have not guilty on top and then guilty on the bottom.
Thank you very much, Your Honor. Thank you to prosecution.
So 515 is standard then, and then we have the closing instructions, which we will handle when the time comes. My practice for polling the jury is if the verdict is an acquittal on all counts, I'll do a collective polling of the jury, just ask the jurors to raise their hand if that is their verdict. If one or both of the counts result in a guilty verdict, I will individually poll the jurors and have each juror asked individually if that is their verdict. Are there any other changes that the parties are proposing to the jury instructions?
None from the state, Your Honor.
Mr. Lychwick?
None for me, Your Honor.
Then we will print up verdict forms too and have those distributed to the parties before we get to that point so the parties can review those. So in terms of timing, Attorney Thompson, how much do you think you have left with Detective Stern?
Under an hour.
Okay. And then, Mr. Lychwick, you'll have an opportunity to cross-examine Detective Stern. At that point, is the state resting?
Yes.
Okay. We will conclude the testimony of Detective Stern. We will take a break outside the presence of the jury. I'll hear any motions from the defense. I'll talk to you, Mr. Lychwick, about your decision whether or not you want to testify. If you do not testify, you have no other evidence that you're presenting. Is that correct?
I would like to enter into evidence my defense exhibits 1 and 2, the Axon body footage chain of evidence log is for Officer DeBaca and Officer Tyndall for the car stop on the night of 1 December 2024.
So this is just the chain of custody log for that body camera?
Yes, and I believe it's probably already entered into evidence, but I want it entered specifically as my defense exhibit 1 and 2 as proof of to support my allegations of tampering of evidence.
Mr. Lychwick, the only body camera that's been introduced as evidence in this case is the body camera of Detective Stern. And it was only the 2 clips from the interview with you outside your apartment during the execution of the search warrant. There have been no other body cameras introduced into evidence in this case, and the jury has not seen any other body cameras in this case. So the chain of custody doesn't relate to Detective Stern's body camera, correct?
It does not.
Okay. So you are not intending to play the body cameras of those officers, are you?
I could, but I am not able at this time to demonstrate the tampering that was done to it. I don't have the wherewithal to do that at this time. I've been trying to do that over this past 18 months. 8 months when I discovered, through discovery, that the footage was tampered with both digitally, visually, and audially.
What witness are you going to introduce those exhibits in through?
I don't have an expert witness at this time. I wasn't able to come up with one. I'm still searching.
Is the state stipulating to the admission of those exhibits?
No.
Okay. Mr. Lychwick, without an exhibit or without a witness, I don't know how you're going to get those exhibits in. I understand that you've expressed a desire to have an expert witness for many months now, And this case has been pending for a long time. I've discussed with you your right to get an expert and your right to prepare a defense. But the trial was this week, and if you are without an expert witness for that, there's not much you're going to be able to do to get that evidence in and get the allegations in that I think you want to get in. What I will let you do, Mr. Lychwick, is this. When it comes time for, or when we're done with the state's case, when we take that break outside the presence of the jury, what I will allow you to do is provide an offer of proof to the court, and that would become part of the court record. So what it is essentially the testimony that you believe you would have been able to get in had you had an expert witness in this case. Okay? I'll allow you to make that record. I'll take your exhibits as part of your offer of proof, but that would be just for the court record. It's not something that the jury would hear because you don't have the witness to testify about that. So for purposes of appeal, if you want to appeal this case, if you are convicted, your offer of proof would at least be part of the record then.
At this point, it sounds somewhat fair, Your Honor.
Okay. Well, we'll take that up again when we take the break at this close of the case. The close of the state's case.
All right, thank you, Your Honor.
Mr. Lychwick, then if you do not testify and if you do not have any evidence, would you like to formally rest in front of the jury where you say the defense rests, or would you like me to do that on your behalf?
I'll take care of it, Your Honor.
Okay. Then the only other thing I want to go over with the parties here before we bring the jury in are the exhibits. Again, I want to update what my record is of the exhibits and confer with the parties. Attorney Thompson, do you anticipate having more exhibits?
Yes.
Okay, that's fine. We'll do a final count later. Right now, what I have is in and published exhibits 1 through 50, and that includes 1A, 1B, 1C, 28A, 34A, 41A. I'm going to do these in batches of 50 because that's how I have my list organized. Is that correct from the state?
Yes.
And Mr. Lychwick?
I'm not exactly sure, I'm sorry, where we are with what we're discussing here.
Sure, we're discussing the exhibits. I just want to summarize the exhibits that have already been received and published to the jury. So my records show that 1 through 50 plus all of the sub-exhibits with diagrams and markings, 1 through 50 have all been received and published to the jury.
And I believe I objected to all those already anyway.
I think you have, and they have been introduced over your objections. So your objections noted.
Right.
My clerk informed me that we had a problem with 1B. That was the aerial photograph with the markings of Miss Nelson. The system indicated that 1B was captured with Ms. Nelson's markings, and my clerk got the notification that it was captured, but it, for whatever reason, did not save. So unfortunately, we do not have 1B saved in evidence.
Now, is 1B the aerial photograph of the top of the hill or at the point where the decedent's body was discovered?
Exhibit 1 was the Google map of the apartment complex and the surrounding area. 1B was the same Google map with Michelle Nelson's markings for, I think she placed 2 markings on there. One was a line, one was a small circle. We lost the capture of her markings on that exhibit.
So this is separate from the exhibit where I asked the witness to put what was really a dot over the spot where the decedent's body was discovered, proving that it was in that location. This is not having to do with that exhibit, right?
Judge, would it be helpful if I pulled up Exhibit 1?
Sure.
That would help, thank you.
So, Mr. Lychwick, this is Exhibit 1.
Right.
And then Exhibit 1B was this same exhibit, but with Ms. Nelson's markings for, let me review my notes here, I'll tell you. Yes, this was on cross-examination when you had Ms. Nelson mark where the body was, and I believe where she approached.
That is a very important exhibit to my case, Your Honor. I think we should maybe ask her to place her markings there again for the jury to see, to make sure that there is no doubt.
Well, I understand that that was the focus of your cross-examination with Ms. Nelson. It was done while the exhibit was up on the screen. So the jury did see that. The jury saw her making those markings, and it was up on the screen for a little time. So the jury has seen it. It would just be a matter of if the jury requests to view Exhibit 1B again, they would not have that available for their viewing.
Your Honor, I think it's very important that somehow that marking, at least where the decedent's body was discovered, be placed on there again for them in the green highlight marker.
Attorney Thompson?
I think it's pretty clear from all of the other scene exhibits where Mr. Maldonado's body was located. So I agree with the court. The jury, just like they have to rely on their collective memories about individual witnesses' testimony because they're not getting transcripts, this would be a similar scenario where they have to rely on their collective memory about the specific markings on 1B, but I think there are other exhibits in which we could get that information from.
Mr. Lychwick, I tend to agree with the state. I don't think there's much dispute in where this body was. We've seen multiple photographs of the actual location of the body. So the witness's drawing of where she remembers the body is less probative than all of the other exhibits that show exactly where the body was located. Furthermore, as I said, the jury already saw Ms. Nelson place those markings on Exhibit 1, and that was done while the exhibit was up on the screen. So they can rely on their memory of where she made the dot on the exhibit. So unfortunately, it's just not available. It's a glitch in the system. All of the other markings in this case have been captured. We just lost 1B for some reason, and I can't explain why that happened.
Your Honor, that's not satisfactory to me, the defense. I must insist that that marking be placed where she had placed it.
All right. Well, Mr. Lychwick, I note your objection and I note your frustration with it, but at this point, I don't think there's anything we can do to recreate that. So we will move on with the exhibits. For the next batch, 51 through 100, I have all of those received into evidence, and they have all been, that also includes 59A, 80A, 81A, and 87A. All of those exhibits have been published to the jury except for 58, which is the Wiedenhoft CV, 75, which was Ms. Gumman's CV, and 76, which was Ms. Gumman's report. Does the state agree?
Yes.
Mr. Lychwick, do you agree on that?
I don't really understand what I'm agreeing to again at this point.
I'm just recapping which exhibits have been received and which exhibits have been used with the jury.
Have I objected to those particular exhibits already?
Most likely you objected to some of them. A number of them were received while you were sitting mute and not participating. So I don't remember which ones were received over your objection, but your objection, if you made them...
They've been covered already, Your Honor.
Yeah, it would be covered already and it would be part of the court record.
Well, at this point, I don't think there's much I can say about that then.
For the next batch, 101 through 150, I have 101, and then I have 108 through 143, and 145 through 150. That includes 145A, 146A, and 150A. All of those exhibits have been used with the jury except for 108, 109, 110, 111, 113, 115, 117, 140, 142, 143, and 149. Does the state agree?
Yes.
Mr. Lychwick, do you have anything different on that?
I don't really know what these exhibits are. I probably have them in my files here somewhere, but it would take too long to go through them and look at them, and I don't have access to a computer, so I can't just, bring them up. I don't know what I'd be agreeing to or disagreeing to.
Okay, well, if the time comes, the bottom line, Mr. Lychwick, is that it's your responsibility to keep track of the exhibits too. The official court record of what exhibits will be received will be maintained by my clerk. I'm just trying to do a courtesy to the parties to verify that my clerk has the correct information. So that's all. The official record will still be maintained by the clerk. All right, the next batch, 151 through 200, I have all of those exhibits received into evidence except 153 and 154, which are the two boxes of Luger ammunition. There was no 181. Otherwise, everything else is in. And as far as publication to the jury, the ones that have not been published are 151, 151A, 153, 154, 155, 156, 177. That was one of a series of photographs of the L2 vertebrae with Dr. Scheel. The others were used. 177 I did not mark as actually having been used. 179 was not in and not used. I should have specified. I think I forgot about that one. 179 was not in and not used. Otherwise, is that consistent with the state's list?
Can you please repeat what you said regarding 153 and 154, which is the boxes of ammunition? I thought I heard you say they were not admitted.
I have them marked as not admitted, Madam Clerk.
Okay.
I don't have note of either one of those.
Okay.
I know they were referred to. I just don't believe the state has moved those in yet.
Okay.
Mr. Lychwick, is that consistent with your recollection or your memory?
Well, I would definitely object to their being admitted.
Sure, the state hasn't moved yet. I was just asking if the overall list was consistent with your notes or memory. Then the final batch after 201, I have 201 through 212, all admitted and published, and 215 through 219 admitted and published. Is that consistent with the state?
Yes.
Mr. Lychwick?
I wouldn't know what to say at this point with that, Your Honor.
Understand. Very well. Anything else we need to take up before we bring the jury back?
Yes. I have a question for the court. Exhibit 213, which is one I intend to use with Detective Stern, that is a recorded video call of the defendant in the Waukesha County Jail with another individual. Now, he has told the jury, and the jury can see at least that he is in orange, and in this video he will be in orange. It shows him coming out of his cell to start this conversation. So how I intended to try to mitigate is to ask Detective Stern, did you watch a recorded video call between Mr. Lychwick and another individual on June 10th of 2025 and not reference jail? I'm playing a portion of it where you do not see him coming out of the cell. It's towards the end of the conversation. I don't know if the court has any other way in which you want me to continue or additionally try to mitigate, but it's a video call, and that was the best that I could come up with to not draw attention to that fact and instead focus on the words of Mr. Lychwick.
Has that video been provided to the defense?
Yes.
Is it possible to play the video without, or play the file without the video and have it just audio?
That would be fine. When I publish to the jury and when I play it, we can just take it off of the screen so that maybe we can see it here at council table. But that...
The audio would still be going? That would be the easiest way to do that, and then it can be characterized as a call, or you can characterize it as a video call, however you want to, just not reference jail, and then the audio will be played to the jury.
Okay, I can do that. Thank you.
Mr. Lychwick, does that proposal sound appropriate?
It does, but I would like to object. I haven't had a chance to object to the introduction of that piece of material into the prosecution's evidence against me, as that video call was a conversation between myself and, at the time, my power of attorney, Alan D. Fisher. He was my power of attorney. It was a private call, Your Honor. Detective Stern had no right to interfere with that, to snoop into that call.
Attorney Thompson, who is the call with?
It is with Mr. Fisher, but I'm not aware of any kind of power of attorney.
I have paperwork to that effect, Your Honor. I have a draft copy. I don't have access to a Xerox machine here, so I have copies of the draft copy of his contract being my power of attorney, and Mr. Fisher has returned that upon expiration of it. He has returned it, and it is sitting in my mail being held for me at the Waukesha Post Office at 600 Broadway.
What do you have in your possession, a draft contract?
The draft of the actual contract with Mr. Fisher being my power of attorney.
When did you enter into that contractual relationship with him?
I believe it was the later part of the mid portion of the year 2025, probably around March of 2025. And he remained my power of attorney, I think, until October of that year when it expired.
Was the nature of the discussion in this conversation legal matters or anything related
Yes, it was.
to power? Hang on. Or anything related to representation or anything within the purview of a power of attorney, Attorney Thompson?
Well, I'm not sure what the nature of this power of attorney is, whether it's medical or financial, but the nature of this conversation is that this individual confronts Mr. Lychwick with what the evidence says was recovered from his vehicle during the search, and then Mr. Lychwick responds, he doesn't know anything about that gun. He's never seen that gun before. It's inaccurate that it was a Luger that was used to murder Mr. Maldonado. And he also is asked about the items he removed from his storage unit to place in his trunk that where we eventually found the firearm. And Mr. Lychwick acknowledges that those are his war bags and that he lists items that we actually did recover in those bags. So it shows his knowledge of the bags. And what I would argue in closing is that conveniently, that's the one item in the bags that he claims to have no knowledge about, but everything else in those bags he knows about. So it's relevant specifically to this case, but they're not talking about legal theory in this section. If the court would like to have an in-camera review, I can certainly do that. I have the timestamps, but this is specifically related to his acknowledgement of his war bags and the firearm recovered.
Mr. Lychwick, what was the nature of your relationship with this individual in terms of power of attorney? Was this for health care, financial, or what?
It was for everything, Your Honor. He was looking after my interests. He had my life in his hands. I had no one else outside helping me at the time. He was my de facto legal presence outside. He was trying to help me legally as well, find legal representation. He had right to know about this case. He was curious as to, he had looked up, with my permission, the criminal complaint and studied it over, and he was wondering what was in these bags that they were writing up, having taken out of the trunk of my car. And I apprised unashamedly apprised my power of attorney, what was in there. And it was, again, I stress this was a private call between me and my power of attorney.
Well,
by
Mr. Lychwick,
contract.
what did the contract say? Was it a financial power of attorney? Was it a healthcare power of attorney?
It didn't specify. It specifies he is my power of attorney. This is a testimonial that you are my power of attorney. I don't believe I have it with me. It's in another file, but I can bring it for the court. I can access it for the court.
Is it in your materials in your cell?
It's in my materials in my cell. I just can't. It's one of my files in there.
Attorney Galaviz, do you have any knowledge of the power of attorney and what it would encompass?
No, sir. I've communicated with Mr. Fisher, and he represented that he was Mr. Lychwick's power of attorney.
How long is the video?
The clip itself, I would be playing from 24 minutes and 37 seconds to 26 minutes and 6 seconds.
So it's a 2-minute or so video clip?
Yes.
And this is for the purpose of tying the defendant to the items that were recovered in his trunk in his car that he was driving at the time the items were recovered, after police watched him remove those items from the storage unit that lists to the defendant, and the defendant contracted to rent.
Yes.
All right, I'll have to take a look at it. I'm going to take a look at privilege as well. Let me do that now. Do you have it on a thumb drive?
I do, yes.
What exhibit would this be?
This would be 181. Oh, no, I'm sorry, 213.
While the court is reviewing that, Mr. Lychwick, would you be able to find the contract that you have in your materials?
If I could have access to my other files, I'm sure I could locate it, Your Honor.
They're in your cell?
You know what? I just might have it with me because this file contains my attorney.
All right, why don't you take a look at your
my
materials?
attorney-related business. It might, but then I might have filed it with. Let me check here, Your Honor, please. And the state, let me check. I might have it. I just might have it here. This is my attorney sub-file. But I may have.
Attorney Thompson, do you have the thumb drive? All right, we'll take a short break. I'm going to review this. What was the timestamp again, Attorney Thompson?
24 minutes and 37 seconds through 26 minutes and 6 seconds.
And is it labeled as Exhibit 213 on here?
Yes, it is.
Okay, Mr. Lychwick, while I'm reviewing this, you can go through your documents. We'll stand in recess. Quick matter, appearances are the same. The court had an opportunity to review the proposed Exhibit 213 on the thumb drive from 2437 timestamp to 2606. The court also notes that Mr. Lychwick was able to produce a 4-page document, both sides, that my clerk has copied and will be made part of the court file. A copy has been provided to the state as well. What the court reviewed was that clip as well as some of the context surrounding that clip, because I wanted to get a sense of how the conversation with Mr. Lychwick and the other individuals started and what the parameters of their conversation was about. The court does note that at a couple of times before the proposed Exhibit 213, particularly at 8 minutes and 55 seconds of the video, Mr. Lychwick makes reference to trying to pay this other individual and pay his expenses. And it's clear that the other individual had already looked into Mr. Lychwick's car situation. The individual was at the defendant's apartment, and that the individual had access to Mr. Lychwick's mail and bills and knew Mr. Lychwick's utility balance and other things like that. I briefly reviewed the contract, which is titled a draft power of attorney. What the court finds important here are the differences between an attorney-client relationship and a power of attorney. The attorney-client privilege is discussed in Chapter 905 of the Wisconsin statutes, and under 905.03, lawyer-client privilege applies to the relationship between a client, who in this case is a person, and a lawyer, who is a person authorized or reasonably believed by the client to be authorized to practice law in any state or nation. That is different from Chapter 244, which covers powers of attorney. Under Chapter 244, specifically 244.02 sub 9, a power of attorney is a writing or other record that grants authority to an agent to act in the place of the principal, whether or not the term power of attorney is used. Essentially, what this document is, and what Mr. Lychwick says is his relationship with this individual, is a power of attorney, which grants this other individual the power to act in place of Mr. Lychwick. That is different than acting as a lawyer that would establish a lawyer-client privilege. In that case, a lawyer is someone who's authorized to practice law. There's no indication that this other person is authorized to practice law. And throughout the conversation with this individual, Mr. Lychwick makes reference to consulting with his lawyer. So this was during a time when Mr. Lychwick had representation of a criminal defense lawyer to handle this case. Mr. Lychwick had conversations with the other individual about his lawyer. And the portion that the state proposes to be played from 2437 to 2606 is not in furtherance of legal representation. It's not asking the other individual to make certain representations to Mr. Lychwick's attorney. It's not asking this other individual to stand in Mr. Lychwick's place and have a further conversation with an attorney that would trigger an attorney-client privilege. So I don't believe that this conversation implicates a lawyer-client privilege. The power of attorney is much different than what would be considered a lawyer-client relationship. And therefore, for that reason, I will, over the defendant's objection, allow the state to play 213 from 24 minutes, 37 seconds to 26 minutes and 6 seconds. As I said before, we'll play it audio only so that the video does not demonstrate that Mr. Lychwick is in custody. If the video were played, it's clear that Mr. Lychwick is in jail. All right, the documents that Mr. Lychwick submitted will be made a part of the record, Mr. Lychwick, so that preserves your objection for appeal. Anything else then from the state before we bring the jury in?
I would just note that When you, assuming that I have Mr. Fisher's name spelled correctly as Allenfisher, he is not a licensed attorney, at least not in the state of Wisconsin.
Okay, thank you. Mr. Lychwick, anything else before we bring the jury in?
I can't think of anything, Your Honor.
Okay, then let's call for the jury.
Yeah, we'll be swearing today. Thank you for reminding me.
All rise for the jury.
Thank you. You may be seated. Good morning, ladies and gentlemen. I apologize for the delay in getting you back into the courtroom. Sometimes I'm pretty good at judging the amount of time that we're going to need, and other times I'm not as good at estimating the amount of time we need. And other times things come up that we just can't foresee. So we've taken care of a lot of legal issues, though, that otherwise would have required additional breaks as we go through this morning. So at least you can take comfort in knowing that we knocked out a number of other things and can get going now. So with that, Detective, you are still on the witness stand. I'm going to have you come back up and be re-sworn this morning.
Do you swear that the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Attorney Thompson, you may proceed.
Thank you. Detective Stern, there are a couple areas that I'd like to circle back on with you before I finish where we left off yesterday. In front of you on the witness stand, do you see exhibits 153 and 154?
Yes.
And can you remind us what those exhibits are?
These are boxes of 9mm ammunition that was located in the trunk of Mr. Lychwick's vehicle.
Was that as a result of the search warrant that was executed on December 2nd of 2024?
Correct.
I would move exhibits 153 and 154 into evidence.
Mr. Lychwick, any objection to the admission of 153 and 154?
I object.
Okay. Over the objection, the evidence will be received.
Now, Detective Stern, we also talked yesterday about the grid search that was performed the day after Moxie went through the property at 1512 East North. Do you recall that topic
Yeah.
of your testimony?
Yes.
And you were referencing divots that you observed at the top of the hill in the area of one of Moxie's trained final responses. Do you recall that as well?
Yes.
Do you remember approximately what time on November 20th you and your other officers went back to this property to actually conduct this grid search?
I don't recall the exact time. I would estimate it around 10 to 11 a.m.
Was it light out or dark out?
It was light out.
Okay. Now, was Specialist Schmidt taking photographs during this grid search?
Yes.
Madam Clerk, can you turn on the screen, please, for the witness only? Detective Stern, I'm showing you what is marked as State's Exhibit 220. Do you know what Exhibit 220 is?
Yes, this is one of the photographs taken during the grid search.
And what specifically does Exhibit 220 document from this grid search?
These are the two divots that I described yesterday.
And, well, actually, first, I would move Exhibit 220 into evidence and ask to publish to the jury.
Any objection to the receipt of Exhibit 220?
Yes, I object.
That objection is noted. Exhibit 220 will be received. Any objection to publication of 220, Mr.
I
Lychwick?
object.
All right, and again, Exhibit 220 will be allowed to be published.
Now, first on your screen, Detective Stern, I'm showing you what has previously been admitted and published to the jury as Exhibit 87. Can you remind us what is in Exhibit 87?
This is what we've been referring to as the top of the hill, the far back portion of the property at 1512 East North Street. And that further back where you see the more of the green coming up, that was the area that we discussed the final train response from K9 Moxie.
And if we look at Exhibit 220, can you circle for me where you see these divots that you're talking about? Can we please screen capture this and mark it as 220A, and I would ask that it be received?
Yes, it will be received as 220A with the markings. Please wait a moment while we confirm the capture.
I have it.
Now, Madam Clerk, can you please clear the screen for me? If we go back to Exhibit 87 here, Detective Stern, I'm going to ask you to mark two different areas of Exhibit 87, if you can remember. Can you please circle where Moxie had her final trained response in this area? And then can you also circle or put an X where these divots are that we just saw in Exhibit 220? Can we please screen capture this and mark it as Exhibit 87B? And I would ask that it be received.
It will be received as 87B, just to clarify the record. Then the first markings that the detective put include the green arrow, which is simply a product of touching the screen, and then the green line right above the arrow. The second marking for the divot was placed where the X is.
Thank you.
I have it.
Thank you. Now, Detective Stern, on November 20th, when you and your fellow officers were conducting this grid search, what was, sorry, I'm trying to think of how exactly I'd like to ask this. Strike that. When you and your fellow officers are conducting this grid search, is it easy or difficult or something else to hear each other?
It was difficult to hear up there. That was one of the biggest notices I noted, one of the things that we noted the most. This was the most amount of time we spent up there based on the methodical grid search that we were doing that day. We noted that you can't really see the road from there, and with the traffic noise during the daytime and some wind that was coming through, we were having difficulty hearing each other while we were speaking to each other. And we were speaking about that as we were conducting this grid search.
Now, how far away are you guys from each other when you're conducting this grid search?
I mean, as we're doing the grid search, if one person's working on one square and one person's working on the other, we're about 3 to 5 feet away from each other.
And approximately how wide were these squares?
Approximately 3 feet by 5 feet.
So, am I understanding correctly that it was difficult to hear each other even though you're only 5 feet away from each other?
That was what we noted.
Now, we left off yesterday talking about Mr. Lychwick's arrest on December 6th of 2024. Do you recall leaving off at that topic?
Yes.
Now, on December 6th of 2024, after he's arrested, is he brought back to the police department?
Yes, he was.
And are you in an interview room with Mr. Lychwick at the department?
Yes, I was.
Were you present when Detective Barrett came in to execute the buccal swab warrant for Mr. Lychwick's buccal swabs?
Yes, I was.
Prior to having any discussions about the facts of this case that we are here to talk about today, did Mr. Lychwick make any comments to you about activities related to German gun shows or arts or pieces of art or artifacts?
Yes, while we were in this interview room, we were making kind of small talk, and he talked about art business that he was involved in, and then he mentioned again that he had traveled a lot back and forth from Germany to America in his youth, how much time he spent there, and then he talked about how he would take artifacts from Germany while he was over there and bring them back, and that he could find people that would purchase them, specifically at antique shows and gun shows.
Madam Clerk, can you turn on the screen just for the witness, please? Detective Stern, when I say an interview room at the City of Waukesha Police Department, are those rooms equipped with audio and visual recording devices?
Yes, they are.
Okay. If you look on the screen in front of you, what is marked as States Exhibit 181, do you recognize the room that you're in?
Yes, this is one of our interview rooms at the Waukesha Police Department.
And do you recognize the individuals in this video?
Yes, I am wearing a green jacket. Mr. Lychwick is wearing a gray long-sleeve shirt.
Okay. And this particular clip, which is 58 seconds long, does that detail the conversation or record the conversation topic that you just testified about?
I believe it will.
I would ask that Exhibit 181 be received, and I would ask to publish to the jury.
Any objection to the receipt of Exhibit 181, Mr. Lychwick?
I object.
Okay, over the objection, it is received. Any objection to the publication?
I object.
Over the objection, it may be played with the jury.
All right, I'm playing from the 0-second mark.
I was already selling antiquities and art since I was like 15, going back and forth from Europe. I started with the military antiques. My dad's buddies at work wanted this, and everything had to have a swastika. I still can't get over that.
Really?
Everything had to have a swastika with these people. I mean, the American collectors, everything, they want this Nazi garbage left over. And there was plenty of it left over in Europe.
Right. Yeah.
I was getting it for nothing over there, and I was bringing it back here, and I was making tons of money. And I was laughing at these people, you know, moth-eaten uniforms and flags, and these guys were almost fighting each other at the gun. I was selling them at gun shows.
Yeah.
And you had all these different types of people there at the gun shows.
There's some crazy.
Yeah.
Some crazy people at the gun shows.
I'm telling you, I remember a lot of the gun shows I went to in Milwaukee, and the Milwaukee County tactical squad guys would be walking through checking for illegal stuff.
Now, on I'm sorry, strike that. Now, the one thing I was going to ask you about the buccal swab is, during your research into Mr. Lychwick, were you able to determine if he had an identical twin?
He does not have an identical twin.
Did you talk earlier about how he had a younger brother?
Yes, he does have a younger brother.
Okay. Now, did there come a time where you reviewed a recording that involved Mr. Lychwick and another individual on June 10th of 2025?
Yes.
And during that recording, was there a part where Mr. Lychwick referenced war bags?
Yes.
Okay. Can you give the jury a general overview of that particular part of that recording?
Yes. During that recording, the individual asked him some questions about information that had been made public post the preliminary hearing. And he then basically discusses what was found in his vehicle. And he describes them as my war bags. He also accurately describes some of the things that were in the bags that we had located from the search, indicating to me that he knew about these bags and that these were his. They were not anybody else's.
I object.
What's your objection, sir?
The prosecution here has their witness inferring that the term war bags is sinister. But as an Air Force veteran, the detective knows that the bags we carried our equipment in were called war bags.
Okay. Mr. Lychwick, your objection is noted. The jury can draw appropriate inferences from the evidence. It's their determination to make. So the objection is overruled, and as far as it relates to the admission of the defendant or the detective's testimony. Go ahead, Attorney Thompson.
Madam Clerk, can you please turn on the screen just for the witness? Detective Stern, up on the screen in front of you momentarily will be State's Exhibit 213. Do you see that exhibit?
Yes.
And is this the recording that you listened to from June 10th of 2025 involving Mr. Lychwick?
Yes.
Had you reviewed this portion of the recording prior to your testimony today?
Yes.
And is it a fair and accurate depiction of the recording when you listened to it for the first time and notated that in your report?
Yes.
I would move Exhibit 213 into evidence and ask to publish the audio to the jury.
Any objection to the admission of 213, Mr.
I
Lychwick?
object.
Okay, your objection, as previously discussed, is noted for the record. The court will allow Exhibit 213 to be entered into evidence. Any objection to the publication of the audio only, Mr. Lychwick?
Yes.
All right, your objection's noted, and the court will allow audio publication of Exhibit 213.
Okay. I am starting at 24 minutes and 37 seconds. pausing at 26 minutes and 6 seconds. Detective Stern, is that the conversation that you heard when you first listened to this recording?
Yes.
Now, if we move on then to an additional warrant that you completed during the course of your investigation, specifically related to Mr. Lychwick's Gmail account. Do you recall that?
Yes.
And since the screen is still only up in front of the witness, I am going to show you what has previously been marked as State's Exhibit 214. This is a 12-page document, and as I scroll through, please follow along with me. Okay, do you recognize Exhibit 214?
Yes.
And generally, what does Exhibit 214 contain?
214 contains examples of search terms and visited websites that I received from Google in response to the search warrant that I submitted to them for this case.
And how did you determine what Mr. Lychwick's Gmail account was?
The conradlychwick@gmail.com, as previously discussed, was discovered being used in his phone after that was forensically downloaded and examined.
And when you reviewed those records, do you recall the time frame in which you received the records from Google?
Yes, I requested and was approved by the judge for January 1st of 2024 until, I believe it was December 6th, the time of his arrest.
Okay. Did you go through those Google returns?
Thoroughly.
And do you know about how many pages there were?
The Google returns are a very large document. There is a lot of data that Google holds for those accounts. If I had to estimate pages, it would be thousands, if not tens of thousands, if you were to print them out individually. It is quite a lot of data.
In your experience, or actually, first I will ask, in your capacity as a detective, have you ever prepared warrants for Google records before?
Yes, I have in previous cases.
And have you reviewed Google records before in your past investigations?
Yes, I have.
Based on that experience, are you aware of whether Google or providers of that nature keep things in their records that may not necessarily be maintained on an individual's phone?
Yes, based on my training experience, data that's held on the phone, if you write to the company that owns that account, they will likely have or can have more information than what's actually still contained on the physical phone.
Is Exhibit 214 a document you prepared in anticipation of your testimony in this case?
Yes, it is.
And does it contain any searches or items that you determined were of significance in the investigation into Mr. Lychwick?
Yes, it does.
And are these, how did you prepare this document?
I prepared this document by physically going into the Google returns, specifically the search history portion that was provided to me by them. And then I basically created screenshots of the searches that we found that were likely related to this investigation.
Now, did these records come from Google in UTC form?
Yes, they do. It's standard that these companies will put the timestamps in UTC. Therefore, it's on us to convert them to the proper time zone.
And in this case, when we are converting to the correct central time, depending on the time of year, whether it's daylight savings time or not, would we be subtracting either 5 hours or 6 hours from the UTC time in the Google records?
Correct. Based on whether daylight saving time is in effect or not, based on those dates, It would either be minus 5 hours from UTC as central time or minus 6 hours from UTC as central time.
Okay. I would move Exhibit 214 into evidence and ask to publish to the jury.
Any objection to Exhibit 214, Mr. Lychwick?
I object.
Okay, the court notes also document 94 filed by the state prior to the trial, so based on that as well, the court will allow 214 into evidence. Any objection to publication, Mr. Lychwick?
I object.
The court will allow publication of 214 to the jury.
I am not going to go to the full screen. Instead, I will zoom in because some of this is a little small. Now, Detective Stern, when we start on page 1 of Exhibit 214, what are the first couple pages of this exhibit referencing?
These are various visited sites or search terms regarding storage spaces from November 1st, 2024.
What was the date Mr. Maldonado's remains were recovered?
October 30th, 2024.
Now, when we see in particular, the first two searches on the screen right now, we can see viewed and we can see visited. Do you know what the difference is between the two of those?
I do not.
Okay. Now, if we continue scrolling then, the next search that comes up, so now we have a total of 3 searches on page 1 of this exhibit. Is this another storage search?
KO storage, I believe, is another storage search.
Now, what is the date on these searches again?
November 1st, 2024.
And so if we were to convert the UTC time to central time, would these times be approximately 8:28 a.m., 8:22 a.m., and 8:46 a.m.?
Yes.
Now, did you see more searches related to storage units on November 1st of 2024 then?
Yes.
If we continue to the bottom of page 1 of Exhibit 214, and we continue onto page 2, are there still more searches for various storage units?
Yes.
Okay, now continuing on to page 3, are we still seeing searches for storage units on November 1st of 2024?
Yes.
Now, all of these searches between the first 3 pages of Exhibit 214, if the first one would have been at approximately 8:22 a.m. on November 1st, if we convert it to Central Time, from your review of the records, how long throughout the day was Mr. Lychwick searching for storage units?
I recall that the math that I did between the first and the last one on that day was approximately 9 hours of time.
When you were reviewing these Google records going back to January of 2024 until November 1st of 2024, did you ever see any searches related to storage units on Mr. Lychwick's Gmail returns?
No, from January 1st of 2024 until November 1st, there were no other searches regarding storage units.
Now, in Exhibit 213, we heard something about a 38 referenced by Mr. Lychwick. Do you recall that?
Yes.
Did you see 2 searches in those Google returns from February 1st of 2024 related to that?
Yes.
Okay, can you describe for me what these searches are?
Yep, one is a visited site for 38 special firearms for sale at Bud's Gun Shop. And then another was a searched for 38 cal revolvers available today.
In the search of Mr. Lychwick's vehicle, did you ever recover a 38 caliber revolver or firearm?
During the search of that vehicle, no 38 caliber.
Objection.
What's your objection, Mr. Lychwick?
Item of truth. He's lying.
Mr. Lychwick, that is not a proper objection. I'm instructing the jury to disregard the statement by the defendant. The answer will stand. Detective Stern, you may continue your answer.
Not only during the search of the vehicle, we did not recover or locate any .38 caliber as described in that audio clip that we heard. We searched his apartment twice, and no .38 special as described was ever, of any kind, was ever located in his apartment or his vehicle.
As you continued going through the Google returns, on February 1st of 2024, did you note searches related to jumpsuits or overalls for sale?
Yes.
When we consider what is included in Exhibit 214 later on, did these particular searches become relevant to you in connecting to some of the later searches?
In terms of the searches from the Google return?
Yes.
Yes, they become relevant.
Okay. Now, if we continue then, were there searches on these Google records for carcass disposal?
There were viewed websites. I did not locate any search term that led him to there, but he was this account was using or viewing websites regarding carcass disposal and disposal of spoiled food.
This search that we have in front of us on page 4 of Exhibit 214, what is searched for?
On April 21st, 2024, there is a search for map of landfills in Wisconsin.
Is there a search that happens approximately a half hour after the map of landfills search?
I don't know if it's a search or if it's a viewed site. That's right here is the visited. So it was not a search, but a website where the article was entitled Carcass Movement, Processing, and Disposal. It was from the Wisconsin DNR website.
Okay, and thank you for correcting me on that term. So when you receive these Google returns and you see visited, are you able to click on the link to take you to the article?
Yes.
And did you, in your review and preparation of Exhibit 214, go to that article and include screenshots of it in Exhibit 214?
Yes, the following screenshots are from that link that we see as the visited.
And April 21st of 2024, how many days is that after Mr. Maldonado was murdered?
Approximately 7 days.
And when we consider the date of this search in reference to the trail cam footage from May 2nd of 2024, how many days in between that are there?
Approximately 10 days prior to the videos from May the 2nd.
Now, if we continue scrolling on page 5 now of Exhibit 214, is this the article that we saw was visited regarding carcass movement?
Yes.
And can you describe for the jury then what information is contained in this article?
Yeah, this article is talking about CWD, or I believe it's chronic wasting disease, with deer, moose, elk, and then it notes some sites where there are sample and disposal locations. If someone was to suspect that the animal they may have harvested might have CWD.
I object.
What's your objection?
These inferences are unfounded, unproven connections with this case.
Okay, as far as it relates to relevance, the court will overrule the objection on relevance grounds. And as for inferences, Mr. Lychwick, it is up to the jury to determine the proper inference to be drawn from the evidence introduced. So the court will allow the testimony to stand. Attorney Thompson?
As we continue through Exhibit 214, does the article continue that you have screenshots here?
Yes.
Okay. Now, what are we seeing on page 6 of Exhibit 214?
So this is the Wisconsin DNR's suggestion for how to dispose of a carcass. They're speaking about deer and harvested animals. However, I noted that their opinion was that carcass waste should be disposed of so that it ends up in a landfill. There was some other notable, dispose of your deer carcass waste in a landfill, transfer station, municipality curbside pickup. Bury the deer carcass. That was another suggestion by the DNR on how to handle it.
When we come to the recommendations for hunters section, are there 3 suggestions by the DNR on how to dispose of the deer waste or the carcass?
Yes.
And are they listed in order of effectiveness? Per
Yes.
the DNR.
The DNR, the article indicates the following options are listed in order of effectiveness.
Okay, what are the 3 options?
Dispose of your deer carcass waste in a landfill, bury the deer carcass waste, or return it to the location of the harvest.
As we continue then onto page 7, what did you note about the suggestion in this article about moving a carcass?
The safest option for disposal is to ensure the waste ends up in a landfill.
In your review of these records, was there any suggestion about using opaque or black bags?
You don't see it on this article that there's another article that recovers this, but under the processing your deer, there's the standard direct common sense for hunters or anybody that's handling a carcass to wear rubber gloves and minimize contact and all that.
As we,
Objection.
Your objection?
The defendant was asked whether the color of the bags was important in this article, and he hasn't substantiated that.
Okay.
His explanation.
So the objection is essentially non-responsive. The witness did answer the question and clarified that there was another article that dealt with that, so I'll allow the witness's answer to stand. Again, the jury can infer inferences.
as we continue through and finish the DNR article, at the bottom of page 7 of Exhibit 214, is there a notation for another website that is visited?
Yes, it was another article. This one is from the USDA. How can I dispose of spoiled food safely?
And what is the date of that search?
This is also at April 21st, 2024.
Were you able to then place or follow that link and have a screenshot of what the user would have seen if they had followed that link?
Yes, that link is depicted in the screenshot below the visited annotation.
And what, if anything, did you observe that was relevant to the investigation into Mr. Lychwick?
The USDA's suggestion in this article that was viewed by this account, it's very short and simple. When disposing of spoiled food or products possibly contaminated with botulism, place the food, swollen metal cans or suspect glass jars in a heavy opaque or black garbage bag. Close and place the bag in a regular trash container or bury it in a nearby landfill.
As we continue going through the Google records, did you also observe searches for paper bags?
Yes, I did.
Okay, and are those denoted here at the top of page 8, both on April 21st of 2024 and April 22nd of 24?
Yes.
Now, we have heard some information from the Operation Starling note, which I believe was Exhibit 147, about Minnesota. Do you recall that part of the note?
Yes.
And as you go through these Google returns, did you see searches or visits or viewings related to Minnesota?
Yes.
Okay. Now, February 12th of 2024, what is this search?
Latest Minnesota missing persons.
Then, as we continue, is there a search from actually, sorry, strike that. On page 8 of Exhibit 214, in the two searches closest to the bottom of the screen, what are these searches?
There are two searched terms here. Can stress cause the tongue to swell up? Both of them are the similar search, yes.
Okay. Now, right now, this date is April 16th of 2024 at 4:40 and 25 seconds a.m. in UTC. Is that correct?
That's correct.
So if we go back 5 hours, would Central Time actually be April 15th of 2024 at 11:40 and 25 seconds p.m.?
Yes.
What is the significance of that then related to Mr. Maldonado?
It's approximately 24 hours after he would have been killed.
The next.
Objection.
What's your objection, Mr. Lychwick?
The state and the prosecution do not know exactly when the poor decedent was murdered.
Okay, Mr. Lychwick, that is an inference that the jury can draw, and they can assign the proper weight to the evidence as they see fit. The witness's testimony will be allowed to stand. Attorney Thompson, you may continue.
This next search after the stress question, what is that search for and what date was that?
On May 20th, 2024, there was a search for ACLU, which I believe is the American Civil Liberties Union, for police surveillance.
And approximately how much time is in between this search and the day that Mr. Maldonado was killed?
Approximately 4 to 5 weeks.
As we continue to page...
Objection.
Your objection?
What exactly does that have to do with this case? Relevance.
Okay, the relevance objection is overruled. Attorney Thompson?
Moving to page 9 of Exhibit 214, what was visited by Mr. Lychwick?
He visited basically the link is still twitter.com, but it was specifically Brett Lemoyne, who is a local reporter, and a Twitter post. And
if we, what's the date?
It's October 31st, 2024, 1:29 a.m. in UTC.
So if we subtract 5 hours from that time, what would be the central time, date, and time of this visited action?
I am no good at math, but it's late night on October the 30th.
And did you follow this link to find this particular, or to see what the post was?
Yes, I did.
And is this a screenshot of what you saw when you followed the link?
Yes.
Now, what is the next viewed item that you could see?
The City of Waukesha Police Department.
And if we subtract from UTC time, that would be approximately 9:25 p.m. on October 30th. Is that fair?
Yes.
Now,
Objection, Your Honor.
What's your objection?
At this point, I think everybody in Waukesha was looking up that site to see what was going on there, including my other neighbors.
Mr. Lychwick, that's not an objection that would prevent the testimony from coming into the record. You can argue that inference, but it's not an objection to prevent the testimony. The testimony stands. Attorney Thompson, you may continue.
the section that is on top of page 10 of Exhibit 214, the first box, if you could read that for us, please.
Sure. November 25th of 2024, 3:43 a.m. in UTC. Search for Waukesha News for November shooting.
And first, if we convert that to Central Time, would that then be November 24th at 10:43 p.m.?
Yes.
Okay. Now, in the context of this investigation and that timeline in Exhibit 164 we were looking at, what happened shortly after on November 26th of 2024?
On November 26th, we executed the first search warrant at Mr. Lychwick's apartment.
Okay. Oh, I'm sorry. Go ahead. Now, this is specifically a search that we can see. Is that correct?
Correct.
Okay. Now, on November 24th, Mr. Lychwick searches for Waukesha News for November shooting. At this point in your investigation, had the fact that Mr. Maldonado been shot been released to the public?
As of November 24th, no, it had not.
Objection.
What's your objection?
This has nothing to do with the homicide investigation ongoing at 1512 North Street.
Mr. Lychwick, your objection on relevance is overruled. The testimony will stand. Attorney Thompson, you can continue.
The next box that we see here on page 10 of Exhibit 214, what was visited?
It was a news article entitled "Officers Find Body Wrapped in Tarp Near Frame Park in Waukesha."
And again, in converting this, would that have been November 24th of 2024 at approximately 10:53 p.m.?
Yes.
Did you then follow this link to the article that was visited?
Yes.
Okay. In looking at this particular article, can you see when the original posted date was?
Yes, October 31st, 2024.
Okay. And now Mr. Lychwick is searching for this on November 24th of 2024. Is that correct?
Correct.
Now, as we continue through Exhibit 214, did you then see at the bottom of page 11 any search terms from January 9th and 12th of 2024 that had relevance to you?
Yes, the weather in Sturgeon Lake, Minnesota.
Objection.
Your objection, Mr. Lychwick?
What does that have to do with this case? That's my private life.
Mr. Lychwick, that objection on relevance grounds is overruled. The jury can draw its own inferences from the testimony. Testimony stands. Attorney Thompson?
As we continue through the last page of Exhibit 214, are there additional searches related to an individual listed on the Operation Starling note?
Yes, searches for Raven Tanya Frederick with other various qualifiers behind him.
When we reviewed, and let me know if you'd like to see Exhibit 147, but when we looked at Exhibit 147, do you recall seeing anything related to obstacles or potential obstacles to that operation?
Yes.
Was there anything related to getting in and out of different states?
Yes, there's. If you gave it to me, I'd be able to read it verbatim. Otherwise, I could summarize.
May I have permission to approach?
You may.
Okay. Detective Stern, I've given you State's Exhibit 147, and I'll give you an opportunity to review that.
I have it.
Okay. Is there anything in there about getting in and out of certain states undetected?
Yes. Right here, obstacles to operation. It is secrecy and entering and movement in and around Minnesota without leaving a footprint.
The last search on page 12 of Exhibit
Objection.
2.
Yeah. Are you objecting to that answer or this question?
The answer and the question.
Okay, I'll take your objection to the answer. I haven't heard the question yet, but what's your objection to the answer?
The objection is that, quite simply,
Mr. Lychwick, again, without testifying, give me your legal basis for the objection.
I simply did not search for anything like that.
Mr. Lychwick, without testifying, give me your legal basis.
Lack of connection to the case, lack of proof that this is connected to the case, that I actually looked up something like that?
Okay.
Did they see me look that up?
That's a relevance objection. Your objection, like all of your other relevance objections, are overruled at this time. The jury can draw its own inferences from the testimony and determine the weight, if any, to give to this testimony. The answer will stand. I will hear the next question in its entirety. If you have an objection to the question, you may voice it at that time. Attorney Thompson?
What is the last searched for item on page 12 of Exhibit 214?
March 3rd, 2024, 6:51 a.m. UTC. Are there license plate readers at the Minnesota-Wisconsin border?
What is a license plate reader?
That would be a camera that would capture a license plate.
Thank you, Madam Clerk. You can take down the screen now. I do not have any other questions for this witness.
All right. Mr. Lychwick, cross-examination.
Detective Stern, you have maintained that you became suspicious of me because you stated that the victim's name was not on your search warrant, your first search warrant that you furnished me with on the 26th of November, 2024, and that I blurted out the victim's name while reading the search warrant. Is that correct?
I first became suspicious of you when you were identified in the May 2nd videos. However, I understand, I know what topic you're speaking of, yes.
But yet I have here a copy of the search warrant that was given to me in discovery, and the original copy of the search warrant is still in my apartment. And it states in there clearly.
Well, hang on. I don't want you to testify. If you have a copy of the search warrant, you can show it to the witness. My bailiff can have it delivered to the witness. The state will be able to see it first. Attorney Thompson, are you going to have any further exhibits after 220A?
No.
Then this will be marked as 221.
Okay.
I refer the witness to look at page 2.
Well, he has to have the document first. Mr. Lychwick, we're going to mark this as Exhibit 221.
Okay.
I'll have the bailiff show it to Attorney Thompson.
This is the final page of it. This is the final page of it. On page 2, Detective Stern, I believe paragraph 2, what does it read?
Carlos Maldonado's name is on this document.
That's correct, isn't it? Isn't it, Detective? Yet you maintain in your official reports even, and led this jury in court to believe that the guilty man would only know the victim's name, and that you're inferring that I was guilty of this crime because I blurted out his name, and you're saying it wasn't on there. You were lying, Detective, weren't you?
No, I was not lying.
But you stated a fact that was not in evidence here, that was not real, that was not in reality.
I did not testify to this during this trial.
But you did maintain in your official reports that are being used in this trial that's why you became suspicious of me?
No. Again, the suspicion arose from the May 2nd videos. There is an error in my report where I believed that the name was not in there based on the draft that I had written.
Oh, now you're admitting that there was an error, but you don't bother to clarify that before now.
I'm going to object first. He didn't even let the witness finish, and second, it's argumentative.
Okay, it is argumentative. I'm going to allow the witness to finish answering the question that you posed. Detective Stern?
When I wrote my report, I did note his use of the name. I believe that based on the draft that I had written, which did not include the name, that was accurate. His name is on this warrant that was presented to him.
Okay, Mr. Lychwick, your next question.
Detective Stern, are you familiar with the search of the boiler room at my apartment building there?
Yes.
And you're aware then that the cadaver dog alerted to the boiler room, the interior of the boiler room?
Yes.
And are you aware that I had no access to the boiler room?
I'm not aware one way or the other if you had access to the boiler room or not.
You didn't bother to check that out, Detective?
I'm aware that you did not have a key issued to you for
That's
the boiler
right.
room.
There was no way I could have gotten into the boiler. I've never been in the boiler room. Was my scent discovered in the boiler room?
Okay, hang on. The jury will disregard the testimony of the defendant about whether or not he was in the boiler room. You have to ask questions. I think you were about to ask a question about whether or not your scent was detected in the boiler room.
That's correct, Your Honor.
Okay. Ask that question.
Was my scent detected by the cadaver dog in the boiler room?
My understanding of the cadaver, I'm not a canine handler, specifically you'd have to refer back to Ms. Gumman's testimony. The dog does not look for specific people's scents.
In your opinion as a detective in this investigating this matter, the lead detective, did you ever suspect that I had any access to the boiler room?
There were times when we were on the property where the boiler room was left wide open. So in theory, anyone who could get into the garage could get into the boiler room. But I am aware that he was not issued the key when it was supposed to be locked for the boiler room.
Are you aware that the boiler room was almost always locked?
I'm not aware because
I will ask Mr.
Hang on. You've asked a question. Let him answer.
I'm not aware because I do not have 24/7 surveillance on the state of the boiler room if the door is left open or not. We noted when we were there several times throughout this investigation, sometimes it would be open with no one around.
Well, I can prove then my point if I could summon the building's owner, Mr. Solper, to testify.
Mr. Lychwick, you have to ask a question of this witness. Ask a question. Do not testify.
Did you ever talk to Jeff Solper about the access to the boiler room and how often it's locked or left open?
I personally did not talk to him about that.
Did he ever mention anything to you about this?
No, because I did not talk to him about that.
Are you aware of your interviews and initial suspicion of the building's groundkeeper named Nathan Pauly?
Yes.
And are you aware that Mr. Pauly did have access to the boiler room?
Yes.
Are you also aware that Mr. Pauly spent a lot of time habituating the area, the actual area in which the decedent's body was discovered?
No, I'm not aware of that.
I was told that you knew everything about this case.
I'm going to object. That's not a question.
That is argumentative. That is stricken. The jury is to disregard that. Mr. Lychwick, ask a question.
Did you ever interview any of my neighbors or other witnesses at my building who saw Mr. Pauly habituating the area where the decedent's body was recovered?
I'm going to object because that is going to call for hearsay.
No, the question was, did you interview any other neighbors or witnesses? So I'll overrule the objection. The witness can answer.
Yes, I interviewed neighbors and witnesses, not regarding Mr. Poli. I would reflect back to Detective Bloom's testimony about Mr. Poli being eliminated as a suspect in this case.
He may have been eliminated and a suspect in this case, but that is not the specific questions at hand right now.
That's also not a question, Mr. Lychwick. Ask a question.
Detective, was Mr. Poli, Nathan Poli, of apartment 1 at 1512 East North Street, an initial suspect in this homicide?
Yes, he was investigated as a potential suspect.
And was he cooperative with you and your department?
Yes, he was.
Your Honor, this contradicts
Mr. Lychwick, ask another question.
Was Mr. Poli ever uncooperative during your investigation of this matter?
No, as Detective Bloom already testified, he provided consent for the search of his apartment, the download of his cell phone, a DNA sample, all sorts of things that helped us continue this investigation early on.
Detective, regarding the missing .38 caliber pistol from my war bags, do you have a gun collection?
I'm going to object as to relevance.
Mr. Lychwick, what's the relevance of this witness's personal gun collection?
This has relevance at 2 points, Your Honor. To try to possibly connect the the detective to the presence of this firearm supposedly found in my war bags, and the missing .38 caliber pistol from the war bags.
Okay. The court fails to see the relevance in whether or not this witness keeps a personal gun collection. So on that basis, the objection is sustained. Next question.
Detective, in my attempts to retrieve my brand new cell phone that you confiscated from me and my other phone, especially before I had to purchase another phone, even though I had visited the station several times trying to get my phone back, you had initially promised me that you would return it right away and that the search of my phone would only take but a day. Is that not correct?
That sounds familiar, yes.
But yet you refused to return my phone. So you were being untruthful, weren't you?
No, I was not. To provide context for why not is because if there was nothing on the phone, then yes, it could have been returned as soon as it was searched. However, evidential value items were found after the phone, and the best practice is to not only use the download that was created, that image by Detective Fine, but to keep the original phone if there was ever a question of whether that download did in fact come from that phone. So I could not return that phone after it was determined that it had evidential value.
You still weren't telling me the truth, were you, Detective?
I don't believe that's an accurate characterization.
The truth would have been to level with me and tell me what you were doing and to apologize for not returning the phone as you had promised. But you did not do that, did you? You were deliberately misleading me, weren't you?
I was not deliberately misleading. Once again, I don't know what's on the phone at the time that it's seized. If there was nothing of evidentiary value, then yes, the phone would have been returned. However, evidential value was located, so we kept the phone. There was no intention to deceive Mr. Lychwick.
But after, you know, it was supposed to be returned and you weren't returning it is what I'm referring to. You still didn't level with me. You were deliberately being misleading in this matter.
I'm going to object. That's asked and answered.
Objection sustained. This has been asked. It has been answered. Next question.
Your Honor, I'm trying to establish the credibility, the integrity of this witness.
The objection is sustained. Next question.
Detective, are you and any other police officers that you know involved in the fraudulent creation of case materials against citizens such as myself that you know are innocent?
I'm going to object as to relevance, and quite frankly, it's argumentative too.
Sustained on those grounds. It's argumentative. It's not relevant. Next question, Mr. Lychwick.
Detective, are you at all fearful of being exposed for corrupt conduct in this case?
I'm going to object.
Same objection, same ruling. Mr. Lychwick, ask an appropriate question.
I'm trying to, Your Honor. I really am.
Next question.
Detective, as far as one's movement around one's own property, or even on the street at any hour of the day or night, are we at Marshall, at the time of your investigation, before I was arrested and moving around on Mr. Lefebvre's camera in the backyard there, were we at martial law in this country, or was there a curfew established prohibiting citizens to be indoors instead of outdoors at those hours?
No.
Thank you. Do you have any proof that I walked on the so-called footpath towards the poor victim's body?
No, there's no definitive video showing that. We showed you the extent of the videos that we characterized to you as detectives believing that it was suspicious, that I believe it was suspicious.
Just answer the question, Detective, please. You've answered it. You said that you have no proof. Detective, on the mud that you and the prosecution are making such an issue about, that I was scraping off of my boots at the end of my hike through the back of my yard. Do you have any proof of where that mud came from, that it had any link to this case, or the poor victim's location where he was resting there at the crime scene?
No.
Thank you. The L-shaped holster on my list that you refer to as a holster, do you now, I believe in your reports you admit you now, but the jury has not heard of this yet, I believe. You now admit that you know what that was. That was an old camera case, right? And you understand that the item in it was the green camping flashlight that you found in my car.
I'm going to object. That was never testified to. That's facts not in evidence. And the form of the question.
Your Honor.
Ask that as a question. Are you asking the witness, does he know if the L-shaped holster was a camera case and a flashlight? Is that your question?
Yes, it is.
Okay. The witness may answer that.
No, I do not know what's on his hip in those videos.
Did you not later discover what it was?
No, I still don't know exactly, to say definitively, what's on his hip in that video.
But if it pleased the court, you did seize those items from me. You have the case, it's in evidence, and you have the green flashlight, which was just shown to the jury yesterday.
Yes, there was a green bendy flashlight. It would require me to render my opinion. I don't believe the silhouette of in the video displays the very short flashlight. You'd have to compare it for yourselves to make that determination. Ultimately, I don't know what's on his hip in those videos.
Detective, in any way, shape, or form, as a man who's handled firearms and who has at least seen this evidentiary firearm that you're saying that you're maintaining was used in the homicide you're trying to link to me, can you sit there and tell the jury that you think that odd-shaped, awkward-looking pistol was on my hip in those frames?
Again, I'm not saying what is or is not on his hip. I'm saying I can't. I'm not saying that it's a gun. I'm not saying it's a flashlight. I'm just noting the piece of equipment that he was wearing in that video.
Okay, Detective, but to try to explain this matter to you further and for the sake of the jury and the court, in your reports on this matter, which I can dig out if I have to, you maintain, you're trying to, in the report it's clear that you are trying to make that look sinister by saying you felt it was a gun on the suspect's hip. Is that correct, Lieutenant? Is that correct, Detective?
Yes, I believe that the phrasing I use is that it is potentially consistent with.
Detective, in your work and your report writing as a police officer, do you use the terms operations and staging area and so forth a lot?
No, not in my work as a police officer.
But those are terms used in your work.
No, they're not.
You don't use the word operations?
Perhaps the TAC team or police, I'm not on the TAC team. They may use an operation or a staging area. Just in my general work as a detective, no, I don't use those phrases.
But you are familiar with those phrases because you have contact with the tactical team. Is that correct?
That's correct.
Thank you. Detective, when you and Detective Smith, or Specialist Smith, I'm sorry, I can't remember his title at this time, when you were in the pole barn methodically searching my car, my 2022 Kia Forte, do you not admit that you don't know what the duct tape that was in there, like anybody may have, was used for? That it only resembles what you're trying to link to this case.
Can you rephrase that, please?
Sure. Do you admit that you do not know what the duct tape that you located in my car, which was, first of all, Lieutenant, a sub-question.
Hang on. Okay. We got to ask really simple questions here. Okay. So ask a one-part question. Are you asking the witness, does he know for sure what the duct tape was used for? Or if you have another question in mind, just ask a nice, simple question that this witness can easily give an answer to.
Detective, do you know what the duct tape was used for?
No, I don't know what anybody uses any of their personal items for because I'm not watching them 24/7. So no, I don't know what the duct tape may or may not have been used for.
All right, thank you. And in your opinion, when you found this particular roll of duct tape in my car in December of 2024 during your initially unwarranted car stop, the search was warranted. In your opinion, was the roll of tape brand new or was it used?
I'm going to object to that question. That is a legal conclusion for the court, which has already been decided, and the court has previously told Mr. Lychwick that.
The objection is sustained. The court is striking the question. Mr. Lychwick, you can ask a question without the editorializing.
I wasn't aware I was editorializing, Your Honor.
The issue of the stop of the vehicle and the search of the vehicle has been ruled on by the court. Ask a question.
Your Honor, I was stating what was already.
Ask a question.
So, Detective, you bring up the fact that I had to purchase a new phone, which, for all what you know, I would have done anyway, because the phone that you initially seized from me was an older phone, was it not? It was an older model of the Samsung series of cell phones, right, Lieutenant? Right, Detective?
I know that it was a Samsung A12. I'm not familiar with where that falls in their model. I don't know if it's older or not.
And then the second phone that you seized from me was my Samsung A15. Is that correct?
I believe that's accurate, yes.
And are you aware that the Samsung A15 is much better in performance than the Samsung A12?
I'm going to object as to relevance.
Overruled. Do you know?
I do not know, but I would make the assumption it is based on the newer model number.
You have never heard you never heard people talking up this particular phone or used one yourself?
No, I'm not particularly, I don't follow tech. That's not one of my things. I have my phone. I personally use Apple, so I'm not familiar with Samsung.
As far as my having to rent a new car when you were in possession of my car, I mean, from your reports already in evidence, you have seen that I was researching legal advice on this case already, and I was looking into filing a complaint against you and your department with the Fire and Police Commission, which is rather difficult to find in Waukesha. I had to do considerable searches to find
Judge,
it.
I'm going to object. I'm sorry to interrupt, but this is not a question, and it's the editorializing that the court
I'm trying to
has.
build up for my question, Your Honor.
I know where the question was going, and based upon what's in your question already, I'm sustaining the objection. That is not relevant. It has nothing to do with the facts that the jury needs to consider in this case. So confine yourself to questions that have relevance to what's at issue here.
I'm trying to, Your Honor. Detective, do you know exactly why I had to rent the rental car from Enterprise Rent-A-Car?
No, I don't know why, especially as I've previously testified. I offered and even drove to his house once to give him a ride back, that car could be released and would have been released to him. So I do not know why he rented a new car.
Do you know why I did not want to get into your car with you at that point and ride back to your station with you after your reluctance to return my things to me and after what you did to my apartment?
No, I don't know why.
Yet you make an issue of it. Why did you make an issue of it?
Because in the totality of the circumstances of what we've been looking at, what I knew at the time that we did that, at that point I knew about the matching of the ballistics and the DNA. Basically, based on the totality, I'm noting it as a suspicious behavior. I found it to be a suspicious behavior. We were going to give him his car back. We made several attempts, and he didn't.
You found that suspicious?
I did, yes.
That's a personal opinion. That's not any proven fact.
That's correct.
Thank you. Detective, are you also aware that I believe it was your second suspect was the decedent's girlfriend in this case?
Yes, there was another suspect in this case as well.
And may I ask the defendant to answer a question about the decedent's girlfriend?
The witness, you mean?
May I ask the witness of this?
I don't know what the question is going to be.
The question would be, did the decedent's girlfriend have any, did she have a father, a brother who may have gotten involved in this case? Did they suspect any of her relatives?
You can answer that question.
Yes, both the decedent's girlfriend was investigated as a potential suspect, as well as her son-in-law was investigated as a potential suspect, both of whom were ruled out after the same residential search warrants, searches of cell phones, cell data, all of that went into each one of these three people that he's referencing, and nobody else provided any evidence that they were involved in this incident. Only one person had evidence that they were involved with this homicide.
Detective, is it possible that you missed something along the way?
Anything is possible, but I do not have any evidence to suggest that there was something missed.
Would you, may I ask the defendant, may I ask the detective to reiterate that anything is possible?
The answer stands. The jury heard it.
All right, thank you. Detective, did you suspect a motive initially of how and why this poor deceased girlfriend may have been involved in his homicide?
I'm going to object to that, and the basis is relevance, and I believe it is coming very close to the court's pretrial rulings on this issue.
The court sustains the objection. Mr. Lychwick, you've established that there were other suspects. The witness has answered that those suspects were ruled out. Motive is not anything that needs to be proven in a case, and the jury will be instructed about that anyway. So at this point, we're getting away from relevant evidence, and the court has already ruled pretrial. So you may continue with your questions.
Detective, on the matter again, if I could bring you back to Nathan Pauly, your first suspect in this homicide, this dreadful homicide, if you will. Is it true that your department was charged with trying to find Mr. Pauly to testify here during these proceedings?
During which time frame?
Just before we convened on the 8th of June, in the week at least before the trial began.
I was on vacation personally in the 2 weeks before this trial. I am not aware of what was going on at our apartment. I wouldn't be able to speak to what anybody was doing.
Are you aware that, are you at all aware of the fact that Mr. Pauly is missing?
No, I don't believe that he's missing.
You're not aware of that, Detective?
No.
Interesting.
Move to strike.
That's stricken. Mr. Lychwick, we don't need the editorial comments.
Again, Your Honor, I wasn't aware I was editorializing. I'm sorry.
When you make comments after the witness's answer, that is editorializing. Ask your next question.
I will try to keep that in mind. Detective, have you ever heard the well-known saying that cops collect guns? They're some of the biggest gun collectors around.
You object to relevance?
What's the relevance?
The relevance is to the suspicious appearance of these firearms in this case and the missing firearm in this case.
Again, whether or not this witness collects guns or knows that police officers collect guns is irrelevant here. Ask your next question.
Detective, when your thugs entered my apartment and destroyed...
That's enough, Mr. Lychwick. Either ask appropriate legal questions or I'm going to stop your cross-examination.
When your men entered my apartment and, Your Honor, and they destroyed my apartment.
Mr. Lychwick, ask a question.
When your men entered my apartment and destroyed my apartment, I have 5 pictures hanging on the living room wall, as you well know.
Judge, I'm going to object. This is going to continue being the defendant testifying.
Mr. Lychwick, what's the relevance of the pictures hanging on your wall?
The relevance, I'm trying to establish the defendant's character and his integrity here.
You are the defendant, Mr. Lychwick.
I mean, I'm sorry, Your Honor. I am trying to establish the detective's integrity and his ethics here, his morality.
If you have, excuse me, if you have an appropriate legal question to ask, you may ask that. But I don't see the relevance of pictures on your wall. The editorializing that the officers destroyed your apartment is improper. So ask a question. If you have a specific question about the search of your apartment.
I do, Your Honor.
Okay, then ask that question.
Detective, I would like to know why members of your team chose to remove my picture of President John Fitzgerald Kennedy from the wall by my office area and throw it on the floor and smash it.
I'm unaware of any damaged property. I don't know anything about that.
You don't?
I do not.
Do you know of any hostile feelings towards President Kennedy or what he stood for amongst your officers?
I'm going to object as to relevance.
Sustained. Next question.
Your Honor, at this time, I believe that's all I have for the witness.
Okay, any redirect, Attorney Thompson?
I do have one question. When we look at Exhibit 87, which is the top of the hill where Moxie's train final response was, are there any lights up there?
No.
What about the footpath area where Mr. Maldonado's body was found?
I believe there's a light adjacent to the parking lot that would provide it there. That light might cast over there, but I don't know if I could say for certain if the light would cast over where the body was found or not.
I don't have any further questions. Thank you.
Mr. Lychwick, would you like Exhibit 221 moved into evidence? That is the search warrant that you showed to the detective.
Yes, please, Your Honor.
Any objection from the state?
No.
All right, Exhibit 221 will be received into evidence. Detective, you may step down. Attorney Thompson?
I do not have any further witnesses. The state would rest subject to any rebuttal.
All right, ladies and gentlemen, the state's initial case is concluded. That necessitates that we take a break. I anticipate that this might be about a 10-minute break, and then we might break early for lunch and come back after lunch. So for now, we'll take a short break, and I will call you back when we are ready. Again, because the state is rested does not mean that it's time to discuss the case.
All right, security.
Thank you. You may be seated. We are outside the presence of the jury. Mr. Lychwick, you indicated earlier that you wanted to make a motion at the close of the state's case.
Yes, Your Honor, I motion to dismiss.
All right. Do you want to present any further argument on that motion?
I have evidence with me today that I would like entered as Defense Exhibit 1 and 2 concerning the Axon body camera chain of custody, which would indicate...
Mr. Lychwick, let me just stop you, and I'll still hear from you. The motion to dismiss asks me to find that the state's case is insufficient as presented at this point. It doesn't have anything to do with any evidence that you would present or whether or not you testify. It's simply asking the court to decide, based only on the evidence and on the inference drawn most favorably to the state, that a jury could not come to the conclusion of guilt here. All right, so do you have any argument on that motion with that in mind?
Yes, I do, Your Honor.
Go ahead.
The evidence against me here, as I have long established for months now, is tainted. This case should have been thrown out 8 months ago at least, Your Honor.
All right. All of that has already been decided by the court and is irrelevant to the motion to dismiss. Nonetheless, the court considers the motion to dismiss, and as stated, the court draws all inferences in the light most favorable to the non-moving party, which is the state here. The court finds that the state has provided evidence here that there was a homicide at 1512 East North Avenue, that the victim was Carlos Maldonado, that the time of death was around April 14th of 2024, that the body was eventually dragged into a wooded area behind the apartment complex and was hidden from view. The state has also provided enough evidence to link the defendant to that homicide through items that were testified to, recovered from his car, his apartment, and certainly other evidence. There was medical information provided to establish the cause and manner of death, and the murder weapon being linked to the defendant. So based upon the evidence presented by the state, the court does find that the state has provided enough evidence for this case to continue to the jury, and the defendant's motion to dismiss at this time is denied. Mr. Lychwick, now is the time to talk about your decision whether or not you want to testify. Have you made a preliminary decision about whether or not you want to testify?
I do not wish to testify, Your Honor.
Okay. Mr. Lychwick, do you understand that you have a constitutional right to testify?
I completely understand that, Your Honor.
And do you understand that you have a constitutional right not to testify?
I understand that, Your Honor.
Do you understand that the decision whether to testify is for you to make?
I understand that, Your Honor.
Has anyone made any threats or promises to you to influence your decision whether or not to testify?
No.
Did you want an opportunity to further discuss this with standby counsel?
I have already discussed this at great length with standby counsel, but thank you for asking.
Have you come to a decision?
I have come to a decision. I do not wish to testify in this trial.
All right. The court will make a finding that Mr. Lychwick is aware of his constitutional rights. He is competent to make the decision whether or not to testify. The court will find that Mr. Lychwick has been following this case. He has asked appropriate and some inappropriate, but he has asked some appropriate questions of the witnesses. He has followed along. He has a certain case theory in mind, and he is smart enough to come to the decision on his own. And therefore, the court will find that the defendant is voluntarily giving up his right to testify and exercising his constitutional right not to testify. So the defendant will not testify, and the jury will be instructed as such, as we discussed earlier. Mr. Lychwick, aside from what I said before about allowing you to make an offer of proof, do you have witnesses that you intend to call?
Not at this time, but I do have the defense exhibits.
Okay. And again, as I stated, I will allow you to introduce those as your offer of proof, but those would not be coming in absent a defense witness. So I'm going to bring the jury back in. I will ask if you have any evidence to present. You indicated that you wanted to rest personally in front of the jury, correct?
That's correct, Your Honor.
All right. You can rest in front of the jury. I will then excuse the jury for lunch. We will come back at it's 11:30. We'll come back probably around 12:45 with the jury, or maybe we'll just say 1 o'clock with the jury. And then I'll excuse the jury. I'll let you make your offer of proof, and then we will break for lunch and we'll come back. Does that sound appropriate, Mr. Lychwick?
It does, Your Honor.
And Attorney Thompson?
Yes.
All right, let's call for the jury then.
What did he say about proof? What proof? When you come back before the jury comes out for closing. It's called what proof? Offer of proof. Offer of proof. Thank you. Okay. Remember, defense reps.
Thank you. You may be seated. Mr. Lychwick, at this time, does the defense wish to present any evidence?
The defense rests, Your Honor.
Okay. Ladies and gentlemen, at this point, the evidence in the case is concluded. You still have to be instructed and you still have to hear closing arguments before you may start your deliberations. Given the timing right now, the fact that it's 11:30, this is a good time to break for lunch. So we are going to break for lunch. We're going to break until 1 p.m. That gives you enough time to get lunch, take a break, for the parties to prepare for closing arguments as well. When you come back from lunch, you will be given the final instructions and hear closing arguments from the parties. So we will see you back at 1. Please do not discuss this case until you come back.
All right, Gary.
You may be seated. We are outside the presence of the jury. Mr. Lychwick, I'll allow you to make your offer of proof. Had you had an expert witness, what do you believe the evidence would have shown?
The evidence would clearly show, Your Honor, that the Waukesha Police Department, headed by this particular investigation and action, was headed by Detective Benjamin Stern and perhaps 7 other of his detectives and specialists and officers, that they deliberately doctored the body camera footage from the car stop of December 1, 2024, at the beginning of the car stop when it initially occurred, and that the audio portion of Officer C.D. Baca in the driveway of my residence when he dropped me off has been deliberately altered.
Okay, Mr. Lychwick, let me just pause you. I'll continue to hear from you, all right? For an offer of proof to have any value on appeal, it has to be evidence-based. So what I'm asking you is, what are the facts, not the conclusions, not the argument, not your inferences, but what are the facts that you think an expert witness would have been able to show for you, and what are the exhibits that you want to introduce? So I don't want to hear you say the evidence was fabricated. My expert will say that the evidence was fabricated. That has no value for you on appeal. So tell me the facts that would have been introduced.
My expert witness will be able to pull apart the digital video, the Axon body camera footage, with a video editor, which is commonly available on any computer, and show what I have brought before the court. They will be able to show timestamps. Perhaps we're hoping to find Detective Fian's digital signature in there. Perhaps his calling card that he leaves when he does his forensic digital searches or modifications. I believe he calls it formatting. When that was done, he almost certainly will have left his calling card, or whoever was operating in the Waukesha Police Department who was doctoring these portions of the Axon body camera footage will have left these in there. It is well known, Your Honor, it is a technical fact that when you, at least at the point that we are now in this technology, that when you alter digital video or audio, there is a sign that you were in there. There is a sign that the person who did it was in there. And we're hoping to expose that, and we're hoping to expose the mere fact that this tampering was done, that these items were changed in these videos. The Axon body camera footage of Officer C.D. Baca and Officer Joshua Tyndall.
Now, Mr. Lychwick, the only times during this trial that I have heard the names of those two witnesses or those two officers has been from you when you voiced your objections. So none of the evidence in this case against you is reliant upon those officers. We have not seen their body cameras. We have not seen body cameras of any witness except for Detective Stern. So the other question that I have for your offer of proof is, what is the relevance of any of that evidence?
The relevance is, Your Honor, that these evidences are directly connected with this case. The car stop was executed, and these items were initially entered as evidence against me and furnished to me in discovery as evidence. And the fact is that they were deliberately altered to try to cover up something within the goings-on of the Waukesha Police Department. I am establishing, may I tell the court what I'm trying to establish here?
Sure.
I am establishing the fact that that my accusers have resorted to the tampering of evidence, and I have come across hard proof that they have, and I have some of it here, if I may go on, Your Honor, in their chain of custody for this evidence, showing considerable alteration with what they call in the if I may use the terms used for this technology, in the alteration of the checksum data. In several places, especially with C.D. Baca's portion of the Axon body camera footage for that date and time frame. And for some suspicious and inordinate activity of the same type within the context of the Axon body camera footage of Officer Joshua Tyndall, who was also responsible for stopping me at that point in which my vehicle was seized, and it is being used. All the evidence is taken from the trunk, and everything are being used as evidence that have been brought up just recently during this portion of the trial as evidence against me. These officers were privy to this, and they were part of this action that is being used against me here, Your Honor.
Mr. Lychwick, do you have exhibits that you want to enter as supporting
Yes, I
your
do,
offer
Your
of
Honor.
proof?
And if I could get back the original search warrant that I provided the court from the
We'll make a
27th.
copy of that. It's Exhibit
For my records.
221.
For my records, Your Honor.
What I'll do, Mr. Lychwick, is I'll take those exhibits that you would have entered and mark them. Are there two of them?
Yes, there are, Your Honor.
Okay, I'll mark them as, we'll say 250 and 251.
Let me just make a note of that, Your Honor. Would this be considered a defense exhibit then, or just an exhibit?
The way we do the numbering doesn't differentiate between state witness and defense, or excuse me, state evidence and defense evidence. It's just sequential ordering, but I'm skipping ahead to 250 just to set these two apart. The last number in sequence was 221, which was your exhibit. But again, it's not labeled as a defense exhibit. It's just Exhibit 221. Anything else you wanted to say regarding your offer of proof, Mr. Lychwick?
Not at this time, Your Honor.
Okay. Anything for the state regarding matters to discuss before we come back at 1 for closings and instructions?
No, thank you.
Mr. Lychwick, anything else?
Not at this time, Your Honor.
Okay. I'll give you time to gather those exhibits, Mr. Lychwick, and submit them with the court. One other thing I'll note, too, consistent with how we've conducted this trial from the start, because of Mr. Lychwick's tethering to the floor, I'm going to have closing arguments delivered from counsel table.
May I stand at counsel table?
You may stand.
Okay, thank you.
And Mr. Lychwick, you may stand as well if you want to at counsel table when you are giving your closing argument.
Thank you.
Okay, we are adjourned until 1. State of Wisconsin versus Kevin Lychwick. Appearances are the same. Attorney Galloway, as standby counsel, is also in the courtroom. The court made just a few minor changes to the final jury instructions. Those all had to do with spacing and pagination. So there were no substantive changes. My plan is to provide 12 copies of the jury instructions to the jury. I figure having all of them with their own copy on this case might be a good idea. And the verdict forms, Madam Clerk, did you submit the previous verdict forms to the parties? Okay. I do have four verdict forms here. They read verdict as to count 1, then there's the not guilty and guilty, and verdict as to count 2, not guilty and guilty. So if either party wants to see those verdicts, they are welcome to, but otherwise the language mirrors what's in the jury instructions. I advised the parties just before we called the case that they are welcome to stand at counsel table. I offered a lapel mic to the state, which I believe they're going to utilize. Mr. Lychwick, you can decline the lapel mic if you want. I just want to make sure that my court reporter can hear you during your closing and make sure that the microphone picks you up. I really don't doubt that the microphone's going to continue to pick you up as long as the microphone's down on your table where it is right now and that you don't cover it with papers or anything like that. It should be fine. Anything else we need to take up before we bring the jury in? Attorney Thompson?
No, thank you.
Mr. Lychwick?
No, Your Honor.
Okay, let's bring the jury in.
For the jury.
Thank you. You may be seated. Ladies and gentlemen of the jury, I'll note that you all have entered the courtroom without your note-taking materials because the evidence portion of the case is over. We're now at the instruction phase where I'm going to instruct you on the principles of law to guide you in your deliberations. Unlike the opening instructions, these ones will be provided to you for reference for your deliberations. In fact, I'm going to print off 12 copies of these so that each of you will have your own copy of the jury instructions. Despite the fact that you're going to be receiving a copy of these, I do urge that you pay close attention to the instructions of the law that I give you now because they will help guide you as you listen to closing arguments as well. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts and the law. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The first count of this information in this case charges that the above-named defendant, on or about April 14th, 2024, in the area of 1512 East North Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Carlos Maldonado with intent to kill that person, contrary to Wisconsin Statute 940.01 sub 1 sub A. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The second count of the information charges that the above-named defendant, between April 14th, 2024 and October 30th, 2024, in the area of 1512 East North Street in the city of Waukesha, Waukesha County, Wisconsin, did hide a corpse with the intent to conceal a crime, contrary to Wisconsin Statute Section 940.11 sub 2. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The defendant has a constitutional right to represent himself. I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself. The defendant has decided to represent himself, and this decision must not influence your verdict in any manner. Standby counsel has been appointed by the court to assist with the efficient operation of the trial. The defendant, though, is still representing himself. The defendant has appeared at times in court wearing orange clothing. You must not infer anything from this. This must not influence your verdict in any manner. First-degree intentional homicide, as defined in 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Element number one, the defendant caused the death of Carlos Maldonado. Cause means that the defendant's act was a substantial factor in producing the death. Element number two, the defendant acted with the intent to kill Carlos Maldonado. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent existed for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Carlos Maldonado with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Hiding or burying a corpse. Section 940.11 sub 2 of the Criminal Code of Wisconsin is violated by one who hides or buries a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. Element number one, the defendant hid a corpse. Element number two, the defendant hid a corpse with intent to conceal a crime. This requires that the defendant acted with a purpose to conceal a crime. You cannot look into a person's mind to find out intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or to hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is defined as, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not establish evidence of guilt by itself. You should give it the weight you believe it deserves under all of the circumstances. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things: whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was accurately restated here at trial, and whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence in determining how much weight, if any, the statement deserves. Remarks of the parties are not evidence. If the remarks suggest certain facts not in evidence, disregard the suggestion. The court has allowed the use of a chart to organize the evidence and to assist you in understanding it. The chart itself is not evidence. It is a summary of some of the evidence that was presented. However, it is the evidence that controls. You should rely on the chart only to the extent that you believe it accurately and properly summarizes the evidence. An exhibit becomes evidence only when it is received by the court. An exhibit marked for identification and not received is not evidence. an exhibit received is evidence whether or not it goes to the jury room. Parties for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of the parties, the court is not indicating any opinion about the evidence. You, the jurors, are the sole judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the court itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony and remarks to be stricken. Disregard all stricken testimony. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining what the credibility of each witness and the weight you give to the testimony of each witness, consider the following factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reason for giving the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. Ordinarily, a witness may testify only about facts. However, in this case, witnesses were allowed to give opinions based on their experiences. In determining the weight you give to this opinion, you should consider the witness's opportunity to observe what happened and the extent to which the opinion is based on that observation. Opinion evidence was received to help you reach a conclusion. However, you are not bound by the opinion of any witness. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. We will now hear the closing arguments of the parties. Because the state bears the burden of proof in this case, the state is allowed to go first and also make a rebuttal closing if they so choose. Attorney Thompson, you may proceed.
Thank you, Judge. Oh, wow, that's really loud. Okay, good afternoon, everyone. Thank you so much for your patience over these last few days. There's been a lot presented to you, and you are here to perform your civic duty, and we very much appreciate it. We're here this week because of Carlos Maldonado, and we're here to find out and prove to you who killed him. And now, at the close of our case, the state has proven to you that Mr. Maldonado was killed by Mr. Lychwick, the defendant. As you heard from the court, the two elements of first-degree intentional homicide are that the defendant caused the death of Mr. Maldonado, and he acted with intent to kill him. We also have an intent element in the second charge of hiding a corpse. So instead of repeating the evidence for both charges, my intent here with closings is to argue how all of these pieces fit together for both charges. First, when we consider intent, as the court said, you can't look into a person's mind, and that's fine. So what do we have here in front of us? Operation Slop Shop. We have dates on exhibit number 146, and it says targets identified. It goes back to November of 2023, and interestingly enough, when we look at those autofill sections on Mr. Lychwick's cell phone, that's when you start seeing Mr. Maldonado's name. And those autofills don't just happen. That is the user who has to manually input those names, and then the phone remembers it. Then we have him on exhibit 146 as the target of the first operation. And the numbering of all four of these operations is very important because when you look at exhibit 147, which is Operation Starling, it says at the bottom, the operation can commence since Operation Slop Shop is completed. Funds and reparations have been seized from Slop Shop, so for Starling, and all threats from the first operation have been neutralized. That first operation is Carlos. Now, how do we know that this note was written by Mr. Lychwick? When we look at all of the pieces surrounding this note, and even some of the context and additional items in there, we know that it belongs to Mr. Lychwick. So number one, it's found in his apartment. That's a really good place to start. He lives alone. He references his brother and his mother. He is next door neighbors with Mr. Maldonado. And think about all those German references. Absolutely fine to enjoy German history, to want to go visit it. That in and of itself is not criminal. But the whole point of playing those clips and showing you those conversations is to provide context and show that these notes belong to Mr. Lychwick and they were written by him. There's another name in Exhibit 146 that we have referenced several times of Raven. The sole reason that the state provided the information and the phone searches and the Google returns about Raven is to connect Mr. Lychwick again to these notes. That is the sole reason. When we look at intent to kill and intent to conceal a body, we're also looking at the medical evidence here. And we heard Dr. Scheel talk all about how they processed this scene, how they brought Mr. Maldonado back, and why they did those x-rays. And her words were very specific. When we have a concealed body, we need to be careful on how we process and examine. And when they do those first set of x-rays, that's when we see the two projectiles, which we'll talk about in a little bit. But Dr. Scheel determined that the cause and manner of death was homicidal violence by the 2 gunshot wounds, and his manner of death was homicide. We may not know how far away Mr. Lychwick was standing from Mr. Maldonado when he shot him. We may not know which gunshot wound came first. But what we do know is that is the epitome of intent to kill. Because that is 2 times you have to pull that trigger. 2 deliberate times. And when we consider the trajectory that Dr. Scheel and Dr. Truesdale talked about when they used that probe, both trajectories of those gunshot wounds were in the right, up, and out the left. Almost as if they came in quick succession to have such a close trajectory to each other. Regardless, though, that's 2 times. We also have evidence that these gunshot wounds are front to back. So Mr. Lychwick is standing right in front of Mr. Maldonado. And let's not forget about the fact that Mr. Maldonado was shot in the face. That is deeply personal. That is intent. That is, I am removing this human being from this earth. That is the target. And that is a surefire way to kill someone by shooting them right in the face. We also heard from Dr. Truesdale about how there were other fracture lines on Mr. Maldonado's skull, and she talked about how that comes from the energy of the bullet, and all that energy needs somewhere to go. When we talk about then how all the threats are neutralized, if that's not intent, I don't know what is. We also then consider the phone searches from Mr. Lychwick's cell phone that we recovered during the search warrant on November 26th. What's interesting here, and what kind of overlaps with the trail camera videos, is that search on April 21st of 2024, 7 days after Mr. Maldonado was murdered, and about 10 days before we see him on that trail cam. He's searching for carcass removal, disposal, how to dispose of spoiled food safely. Sure, it could be innocuous, I guess, but not when you consider everything in the totality. That timing is just too specific. The nature of those searches, the carcass, he's referring to Mr. Maldonado. That's what this evidence shows. Because at that point, he has Mr. Maldonado up on top of that hill in the area in which Moxie gave her trained final response. But this is an apartment complex. This is land that's shared by everybody. And eventually, he'll probably be discovered. And so now, a week later, we have this search of how to get rid of a carcass. And remember that DNR article had 3 options. You can either take it to a landfill, you can take it back to where the harvest originally occurred, or you can bury it. Mr. Lychwick goes a little bit out of order, but it does make sense when you think about the timeline that we've presented to you. So first, we have him on those trail cameras then, 10 days later, with all of his gear. He's got his shovel, he's got his boots, he's got the plastic sheeting, he's got that black packaging with him that looks very, very similar to all of these black garbage bags. And he is up there for 30 minutes where we don't see him anymore, from 12:41 a.m. to 1:10 a.m. And when we see the direction that he's walking, it's exactly the direction up that hill. Because then when you go off camera, you continue going up the hill, or you can divert to that footpath where we eventually found Mr. Maldonado. And there was a lot of talk about something on Mr. Lychwick's hip in that video. Detective Stern said, "I can't tell for sure what that is." And Mr. Lychwick posited that it is a flashlight. Let's go with that. Let's say it is a flashlight. It makes sense in a way, because as you're up there on the top of that clearing, knowing, okay, the DNR suggests that I need to bury a carcass, so I'm going to try digging, and I'm going to bring my shovel out there. There's no lights up there. So of course you need a flashlight to see where you're digging. But then he realizes this isn't going to work. And as Detective Stern talked about, the dirt up there, you can get down a little bit, but then eventually you're hitting clay, you're hitting something harder. And that shovel that we have is not something that's going to be able to break through that. He can't bury Carlos deep enough to avoid detection. So then what does he do? Landfill. That's what we're going to do with this. So he starts dragging him down, because it's a lot easier to go down that hill than it is to go up that hill. So between that and Moxie hitting up there, that's where this all started. So then as he decides, I need to get rid of Mr. Maldonado, I need to get him off of this property, he has him in these opaque black garbage bags, which we saw from the Google returns. He's got the tarp as well, which helps him drag or slide Mr. Maldonado down the hill to this footpath. The ropes, when you look at those ropes that were tied to the chair in Mr. Lychwick's apartment, and you put them side by side with those ropes recovered from Mr. Maldonado at autopsy, look at those patterns. Look and make that comparison, because those are the same kinds of ropes. Because he used what he had. And so even those knots, if you look at how those knots are on each of those 4 ropes, they look pretty close to those photos of the ropes from his apartment. And when we talk about intent to conceal, he's even threading those ropes through the grommets on the tarp. We have tape on Mr. Maldonado's hands. We have that black duct tape that is used to enclose Mr. Maldonado, to tie together or tape together those black plastic garbage bags. And then once he is in this footpath, and we saw a picture of Carlos, he's not a small guy. And so if it's too difficult to get him into a car to bring him to a landfill, I can't drag him back up the hill now, so he's going to have to stay here. And so then we start piling on all of those branches, all that debris, and he goes undetected. Family knows that Carlos isn't here, that he's missing, but nobody sees him anymore. After Home Depot on April 14th, we see from his phone records he comes back to 1512 East North, and then nothing. There's no movement. Nobody sees him again. That combined with what he's wearing on that Home Depot video, and that's what he's wearing when we find his remains, this all goes to establishing April 14th. And even going back to those trail cams, yes, we have that half-hour break, but we never see Mr. Lychwick come back with any of his tools or his gear until 4:39 a.m. that morning. He goes back and forth. We see him go to the garage, We see him walking back up in that direction. So that's 4 hours where he's out there and he's not exercising. That just doesn't make any sense compared to what we saw him bringing out there. So then we talked a lot about the search of Mr. Lychwick's vehicle. And before we get to that point, though, he goes to U-Haul. And that is out of the ordinary for what the detectives have been seeing in terms of his pattern of travel over the last few days. So as he starts traveling north, we follow him to a storage facility that he has no history of searching for until within 48 hours of us finding Mr. Maldonado. He had rented it, according to that receipt, on November 1st, gets that free month promotion, and now he's got to empty everything out because that month is, maybe he's moving it. Maybe he's going to another storage unit. I don't know. But what we know is he emptied it. And then we follow him. And we saw him on the surveillance emptying it. So we follow him back to Waukesha. Officers stop the car. They seize the car. There's nobody else in the car with him. And what do we find after we get a warrant to search his car? The murder weapon. Inside that trunk, we find the shovel. In the back passenger seat, we have boots. We have numerous boxes of 9mm ammunition. So for Mr. Lychwick to say, I've never seen that gun before, I don't know what it is, I don't know how it got there. You certainly have a lot of ammunition for a 9mm. So then we also find all these garbage bags. We start putting all of these pieces together here. What's important to know, and really I'll sum up Ms. Crawford's testimony. She told us all about firearms identification and how we have those striations and those grooves and the manufacturing characteristics versus the individual characteristics. But here's the bottom line. These two projectiles recovered from Mr. Maldonado's body were fired from this gun, period. End of story. So now you have an individual who is targeting the victim. He has his name written in notes. He is up in a trail area at the top of the hill. He is hiding evidence related to a homicide. And you heard on that recording, yeah, they were tearing up everyone's apartments and I had to get my war bags out of there. Your war bags with the murder weapon? Thank you very much. So now we have this, and Ms. Crawford says, yep, this is the murder weapon. Now we go and arrest Mr. Lychwick. We get his buccal swab, which you've heard a lot about. And this is another reason why this whole theory of, I've never seen this gun before, I don't know anything about it. His DNA is all over that gun. When we heard from Ms. Taylor, we talked about the swabs from the grip of the Luger. And it's, in the state's view, important because this is a single source profile. There is no mixture. There is nobody else's DNA from the swab of the grip of this Luger. And it's Mr. Lychwick. And you heard Ms. Taylor talk about how in order to find another profile, or it would take us testing a quadrillion people to see a similar profile. There are not a quadrillion number of people in the world. So there's no question that Mr. Lychwick's DNA is on the grip of this Luger. Then we also look at the towels and the rubber bands. The exterior towel is a mixture, but we have very strong support for inclusion, which is the highest reporting level that our state crime lab has. We also see that quadrillion number again. And then we get to the interior towel, which is back to a single source profile. And it's Mr. Lychwick's. So, ladies and gentlemen, sometimes, and you heard Mr. Lychwick talking about it, objecting to it, sometimes little things, they might seem, well, everyone has bleach. Everyone shops for hand soap. Everyone shops for garbage bags. True. I don't dispute that at all. But you can't take everything and just look at it individually in a vacuum. Your role here is to search for the truth, not to search for doubt. And the truth is that on April 14th of 2024, Mr. Lychwick murdered Mr. Maldonado. And all of the evidence is right here in front of you. And so I'm asking you, when you go back there to deliberate, that you hold Mr. Lychwick accountable and you find him guilty on both counts. Thank you.
Thank you, Attorney Thompson. Mr. Lychwick, you may give your closing argument. You may stand at council table if you would like, and you can also use the lapel microphone if you want.
I think this microphone will suffice, Your Honor.
Go ahead, then.
Ladies and gentlemen of the jury, thank you for coming and giving your precious time and effort to this case. I ask you now to do what you must do, to acquit me of these horrible charges. I am totally innocent of this crime. I did not know this man well enough to hurt him. He did not know me well enough to have attempted to hurt me in any way. We were neighbors, but we did not know each other. The defense argues that I went on top of the hill. They take broad liberties with the truth and with their idea of facts in this case. But the fact is they have no proof that I was ever even on top of that hill. I have established that I have a right to be out in my own yard and do whatever I do. They have no proof that I even spent all the time they're saying I did on the night in question when they're insinuating that I had something to do with the handling of poor Mr. Maldonado. They don't know that I went home and that I was on a hike looking around for possums that lived in my yard and feeding my rabbits because I couldn't sleep that night, that I normally would put my tools down and go for a run up and down the hill or a quick trip to buy groceries at all hours of the day. During the daylight hours, I use a jogging suit. At night, if I'm out in my
I'm going to object at this point. This is all testimony and none of these facts are in evidence.
That's sustained. Mr. Lychwick, I caution you, you can argue inferences and argue what the state doesn't show in their evidence, but you can't testify about matters that have not been testified about. So just be careful that you're not trying to introduce new evidence or testify in any way. You can continue.
Ladies and gentlemen of the jury, as you were instructed to do so, I implore you, if you have any doubts in this matter, to find me not guilty. There are plenty of doubts in this case and what the prosecution has established as their case against me. The accusers, the Waukesha Police Department, headed by the investigative team of Detectives Benjamin Stern here. I implore you to weigh in consideration of my innocence in this matter and to take into consideration the manner in which they executed their search warrant against me. The search warrant being established originally because one of their detectives asked me, I think this has been established as evidence already, asked me about the presence of plastic bags in front of my car, in which I truthfully answered the detective, telling the detective that I moved my shovel and everything into my car for winter.
None of this is in evidence.
It has to be.
It's sustained. It's not in the trial record. The jury has not heard any evidence of this, and the legality of the search warrants and the manner of their execution is not an issue for the jury to determine. You can continue, Mr. Lychwick.
If I may, ladies and gentlemen of the jury, I have been unable to present a hearty defense in this matter because I have been imprisoned in the Waukesha County Jail for 18 months now and isolated from my funds and my family and my friends and my
Judge, I'm
ability
going
to
to
hire an
object.
attorney.
Okay, Mr. Lychwick, stop, please. Again, these are not matters for the jury to consider. They are to consider only the facts and evidence that was presented in the case, not what could have been, not what wasn't, only the facts and evidence that have been presented. Your status during the pendency of this case is not relevant and should not be matters for the jury to know.
But
You
Your Honor,
introduced it, but it should not be for them to know. So focus on the issues here and the evidence that has been received in the trial this week, and you can continue your arguments.
Your Honor, you noted these protests throughout the trial. That
I have. Now continue.
Ladies and gentlemen of the jury, I implore you again, if you have any doubts as to my guilt, please find me innocent. I have a life out there. I am a good man. I am a God-fearing Christian. I just want to go home. I want to resume my life. And when I go home, the Waukesha Police Department and anyone assisting them will be able to continue searching for the actual killer or killers of the poor victim in this matter. As long as I am in custody, they have stopped looking for who actually killed this man. Imagine that whoever did this is still on the street. I implore you to please send me home. Find me not guilty in this matter because I am not guilty in this matter. And owing to the corruptibility of people and human nature, I am telling you there is a corrupt element within our local Waukesha Police Department. And if you find me innocent, perhaps there will be some house cleaning and they can take care of it. Somebody will investigate this matter and we will all be a little safer. I thank you for your time in coming here again. And again, my final statement to you is, if you have any doubts in this matter, if you have any doubts about my guilt, please find me not guilty.
Thank you,
I
Mr.
rest my
Lychwick.
case.
Any rebuttal closing, Attorney Thompson?
Very briefly.
Go ahead.
What I'd like to posit to the jury is there's probably someone else who really wants to go home or wanted to go back to his apartment that night.
I object, Your Honor. She's already had her chance to make her statement in this matter.
The objection is overruled because the state bears the burden of proof in this case. It is allowed by law to give a closing argument and provide a rebuttal closing. So the state gets the last word. Attorney Thompson, you may continue.
Thank you. Mr. Maldonado had plans with his daughter, and she never anticipated that he wasn't coming back to his apartment that night. And so who's responsible for that? Mr. Lychwick. So let's all remember why we are here, because Mr. Lychwick murdered Mr. Maldonado. And that's what this evidence shows. And the law that the judge read you is not, if you have any doubt, you're not searching for doubt. You search for the truth. And the standard is not beyond all doubt. It is
Objection, Your Honor.
What's your
She's trying
objection?
to instruct the jury to find me guilty.
I disagree, Mr. Lychwick. The state is reciting elements of the reasonable doubt instruction. That's permissible. And ultimately, ladies and gentlemen, you are bound to follow the law and the instructions I give you, not the law and the instructions the attorneys may interpret or recite. Ultimately, what's in the jury instructions is what you follow. Attorney Thompson, you may continue.
Thank you. As I said, it's not any doubt. It's not even beyond all doubt. It is beyond a reasonable doubt. When you look at all of these pieces together, just like Dr. Truesdale said, the bones tell a story. They tell a story about someone's life. And all of these pieces of evidence here tell us the story of how Mr. Lychwick murdered Mr. Maldonado and then hid his body so that nobody would find him and hopefully he would get away with what he did.
So I'm asking you to find him guilty on both counts. Thank you.
Thank you. Now, members of the jury, the duties of the parties in the court have been performed. This case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and, as upright citizens, to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 4 forms of verdict will be submitted to you concerning the charges against the defendant, Kevin Lychwick. As to count 1, one verdict reading, we, the jury, find the defendant, Kevin W. Lychwick, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we, the jury, find the defendant, Kevin W. Lychwick, guilty of first-degree intentional homicide as charged in count 1 of the information. As to count 2, 2 verdicts. One reading, we, the jury, find the defendant, Kevin W. Lychwick, not guilty of hiding a corpse as charged in count 2 of the information. Another reading, we, the jury, find the defendant, Kevin W. Lychwick, guilty of hiding a corpse as charged in count 2 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case, and therefore before the jury may return a verdict which may legally be received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the parties before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any question in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with the verdict. We will first swear the officer and then strike the alternates.
Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them, or you speak to them yourself, except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon? So help you God.
I do. Ladies and gentlemen, there are 14 of you, and we can only allow 12 to go back and deliberate on this case, which means we must strike 2 jurors at this time from the jury pool. Those alternates are picked by random. It's probably disappointing if you get selected as an alternate because you've sat through all of this trial and you can't participate. But understand that we pick alternates the way we do just to guarantee that if any emergency comes up or we lose a juror for a family emergency or a medical situation, that we can continue the trial. So we build in a little bit of a buffer to allow for that to happen, especially on multi-day trials. So I have the list here with the alternates. If I read your name as an alternate, I ask that you stand, please. The alternate jurors are Paige Hornack and Nancy Kovacs. Okay, what we're going to do is our jury bailiff will escort you back to the jury room to get any belongings that you may have back there. I'm going to ask the other jurors to remain where they are for now. We'll have those jurors go collect their materials, then they can be released. And once that's done, we'll have the other jurors retire to the jury room.
There is, if you can wait, I can get it to her. Thank you.
I'm now providing a copy of the verdict forms and 12 copies of the jury instructions to the jury bailiff, and the jury may now retire and begin their deliberations.
All rise for the jury.
Thank you. You may be seated. We are now outside the presence of the jury. If the jury requests any of the photographs that were used and published, my inclination would be to provide those to the jury without calling the parties back to go through each one that they've selected. Mr. Lychwick, I recognize that you've objected to a number of the exhibits being introduced. The exhibits that have been introduced and already used with the jury, I would send those back if they request. Do you have any issue with that process?
I certainly do, Your Honor. Especially if I entered a prior objection to them.
And your objection would still be noted to those exhibits, but my point is that they've already been shown to the jury. So if the jury asks a question, I would have to bring you back into the courtroom. I'd have to bring the state's attorneys back. We would confer about the question, provide an answer to the jury. Sometimes that takes a little bit of time, and that's what we will do for ordinary questions. Other times the jury says, hey, could I see exhibits 120 through 130? If those are all photographs that have already been displayed to the jury on the screen, I'm not going to bring the parties back and talk about whether or not those should go back to the jury because they've already been displayed in court. The jury has already seen those. They're just asking to see them again. For photographs, I'm just going to send those back to the jury. For other things where parts of them may have been published, for example, some of the reports were published but not in their entirety, I would not be sending those back automatically. We could discuss that. But I'm just talking about just regular pictures, one-page picture files. If the jury asks for those, I'm going to send them back without bringing the parties in to talk about that if they've already been published. Understand?
I think so, Your Honor.
Okay, that's fine. And I was going to go to the state. Attorney Thompson, that's fine with you?
Yes, I'm sorry.
That's fine. If there's anything else where I see they've requested another exhibit that may have been published in part or something other than just a simple photo, I'll call the parties back. Then with the issue of the videos, if they request to see any of the videos, we do have the capability of streaming the videos directly back into the jury room. We can either do it one of two ways. We can stream it back in the jury room, or we can bring them back into court and play it again on these monitors. I'm going to decide to stream the videos into the jury room. The way we do that is we have one of our bailiffs go back to verify that the streaming and the live feed is live. We will play the videos twice, and then that'll be the extent of how they're played back. Because we can't just send a thumb drive and the videos back to the jury and let them poke around with the videos. We have to control the playback. So that would be the process for the videos. If there's any other questions or any other exhibits that they want to see that don't meet those, well, sorry, let me just be clear. If we live stream the videos, I'm calling the parties back. And we'll reconvene. We'll do it on the record. We just won't have the jury brought in. But otherwise, simple request to see the photographs. I'm not going to bring the parties back to do that. Anything else from the state then before we wait for deliberations?
No, thank you.
Anything else from you, Mr. Lychwick?
Well, thank you, Your Honor.
Okay. Then the state, please provide some contact information, and we will stand in recess until we have a verdict. Lychwick matter, the appearances are the same. Standby counsel is present again in the courtroom. I have been advised that we have a verdict from our jury. We will bring the jury in. Do you have those final ones? Thanks. Yeah, you don't even have to do 525. Just is the 522 just the poll? Yeah. Yeah, please.
All rise for the jury.
Thank you. You may be seated. I have been advised that the jury has a verdict. Is that correct? Is Mr. Morotek the jury foreperson?
Yes.
Okay. Could you please hand the folder to the bailiff? The court will now read the verdict. In the matter of State of Wisconsin versus Kevin Lychwick, verdict as to count 1. We, the jury, find the defendant, Kevin W. Lychwick, guilty of first-degree intentional homicide as charged in count 1 of the information, signed and dated this 11th day of June, 2026, and it bears the foreperson's printed name and signature. Verdict as to count 2. We, the jury, find the defendant, Kevin W. Lychwick, guilty of hiding a corpse as charged in count 2 of the information, signed and dated this 11th day of June, 2026, again bearing the foreperson's printed name and signature. The other 2 verdict forms are left blank. Ladies and gentlemen, I am now going to do a process called polling the jury. It's going to ask each of you individually if these are your verdicts. I'm going to start in the back corner. Ma'am, are these your verdicts? Are these your verdicts, sir?
Yes, Your Honor.
Are these your verdicts?
Yes, Your Honor.
Are these your verdicts?
Yes, Your Honor.
Are these your verdicts?
Yes, it is.
Are these your verdicts?
Yes, Your Honor.
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 Are these your verdicts?
Yes.
And are these your verdicts?
Yes, Your Honor.
Is the state satisfied with the polling?
Yes.
Mr. Lychwick?
I don't know what to say at this point.
Okay. The court has polled all individual jurors, and all jurors have indicated that these are their verdicts. Members of the jury, with the verdict delivered, your service in this case has concluded. Therefore, you may now freely discuss the matter with any individual of your choosing, and all of my restrictions on such discussions have been removed. However, it's important for you to understand that you are under no obligation to discuss this case or answer any questions about it unless I require you at some later date to answer questions about it. This applies to interactions with the parties, their attorneys, the members of the media, any other individuals. Should you choose to discuss the case with others, though, I urge you to approach these conversations with the seriousness that they deserve. I would also recommend that any discussions you engage in are ones that you would feel comfortable having in the company of your fellow jurors and openly in court under oath. While you have the right to speak freely about this case, it is important to remember that discussions in the jury room were conducted in an environment designed to be open and free from fear of reprisal or criticism. Your fellow jurors shared their opinions fully and candidly and may not want their opinions made public. Therefore, I urge you, when you discuss the case and discuss deliberations, you discuss those from your own viewpoint and not the viewpoints of your fellow jurors. Finally, ladies and gentlemen, I have a couple of matters to still discuss with the parties. It'll take probably about 5 minutes or so. If any of you have any questions or feedback that you would like to give me, stick around in the jury room and I will come back and do my best to answer those questions if you have any. Otherwise, on behalf of Waukesha County, I extend my deepest gratitude for your service in this case. I recognize that you have devoted considerable time to this case this week, but your contribution is a vital component of our justice system as enshrined in the United States Constitution and our state constitution. So it's my hope that you have found this experience to be rewarding. You are now discharged in this case. Thank you.
All rise for the jury.
Thank you. You may be seated. We are outside the presence of the jury. Attorney Thompson, any motions from the state?
I would ask that the court enter a judgment of conviction on each count.
Mr. Lychwick, are you moving for judgment of acquittal notwithstanding the verdict?
Yes.
Okay. The court will grant the state's motion and order judgments of conviction as to each count. Mr. Lychwick, I'll advise you that you are a convicted felon now, and as such, you may not use or possess a firearm for the remainder of your life. You also may not vote until your civil rights have been restored. We will schedule this case for sentencing. Attorney Thompson, do you have a specific length of time in mind as to how far out you want to go for sentencing?
I am not requesting a PSI in this case, so at the family's wishes, as soon as the court can accommodate, please.
Mr. Lychwick, there is a mandatory sentence of life imprisonment on count 1. The court does have the ability to determine early release or eligibility for release, I should say. One of the options you can exercise for sentencing is a request for a pre-sentence investigation. The state's not requesting one. I don't particularly need one, I don't think. But if you would like one, we could order a pre-sentence investigation. Otherwise, I could offer a date as early as tomorrow for sentencing.
I would like a pre-sentence investigation, Your Honor.
Okay. I'll allow for the pre-sentence investigation, so we'll schedule the matter accordingly. That'll go out about 60 days, probably.
Thursday, August 20 at 8:30.
That works for the state. Thank you.
August 20 at 8:30 then. The court will order the PSI. The defendant is remanded into custody. And Attorney Galaviz, the court is relieving you of your standby counsel appointment.
Thank you.
Anything else from the state at this time?
No, thank you.
From the defense?
I plan to appeal, Your Honor.
I understand. You will have that right, and I will notify you of your opportunity to appeal after sentencing. We stand adjourned.